item number 4. मतलब 1 week time में भी time. Item number 4.
The matter was presented before this court on 16/3/2021. After 5 years, adjournment is sought for by the learned counsel. You are Mr. Sunil Kumar Patnaik. Sunil Kumar Patnaik. After 5 years of presentation, adjournment is sought for by the learned counsel for the petitioner by making a mention. Stop. Earlier, the matter was listed on 21/11/2025, 6/3/2026, 13/3/2026, and was adjourned. Stop. To grant further opportunity, list in the week commencing 4/5/2026.
Lordship, item 5, may I pray for next week, Your Lordship? Learned senior.
Next week se adjust kar paribe ki nahi? The
Lordship,
defect guda ka remove kar leni?
Lordship, I'll comply the defects.
Is Arunima Pradhan.
Ananya Pradhan.
Sorry, Ananya Pradhan. I'll pass that order. How much time you require?
Lordship, next week or 2 weeks?
Like 5 week के date कर पड़ेगी? Miss Ananya Pradhan for the petitioner. The learned counsel for the petitioner seeks for the time to remove the defects as pointed by the SR. At least in the week commencing 27/4. Na 4/5.
27.
27/4.
4/5.
4/5. ठीक है.
Oblige.
Item number 10, permitted to withdraw.
File your memo or affidavit, whatever. What's your name? What's your name?
Pinky Jain.
Oh, yes, you have power.
Yes, madam. I'm filing that memo.
Yes.
Obliging.
Next.
Item 6, Lordship. I pray for an adjournment, Lordship. And for the petitioner, Lordship.
What's your name, sir?
P.K. Malik, Lordship.
So item 6. Mr. P.K. Malik for the 5 जेतटा अछि सबुडा को removal of defect. बुझले? एक का 2 3 टा. Item 6. P.K. Malik for the petitioner. The matter was presented on 16/5/2024. Was listed on 15/1/2026 when it was adjourned by the instance of the learned counsel for the petitioner. On 17/3/2026, the matter was again adjourned. So, today, the matter is mentioned to be adjourned. The matter is mentioned seeking adjournment. To grant further opportunity, list in the week commencing 11/26. Item 8. Item 8, Mr. S.S. Mahapatra for the petitioner.
I need 2 weeks time to comply Lordship order for payment. Lordship asked me to take instruction whether I had made
The matter was earlier heard on 27/2/2026. The legal issues were noted in the said order. The learned counsel for the petitioners refers to the said order and seeks further adjournment to obtain instruction. Stop. Accordingly, the matter shall be listed in the week commencing 11/5/2026.
Phase 3.
Well, item 11, my lord. I'm prepared.
11 to 18.
No, 11.
Mr. Bipin Kumar Naik for the petitioner. Item 11.
I have already intimated.
The matter was heard on 13/3/2026, and the issues deliberated have been noted in the said order. The learned counsel for the petitioner mentions the matter seeking adjournment. Stop. To grant further opportunity, the matter shall be listed for fresh admission in the week commencing.
11-5.
So, fresh admission in it. 11-5-2026. Yes.
Item 14, Your Lordship. Notice has not been
14.
issued.
14.
Yes, Your Lordship. Notice has not been issued in the matter. I pray for an adjournment, Your Lordship.
What's your name, sir?
Gautam Mishra.
14, Mr. Gautam Mishra for the petition. The matter was heard at some length on 12-3-2026. The legal issues have been noted. Today, the matter being in the list, adjourn is mentioned by the learned counsel seeking adjournment. Stop. To grant further opportunity, list in the week commencing 11-5-2026. Yes.
Lordship, the trial has been posted to 5th of May. The only difficulty is my senior is not available today due to some personal difficulty.
CPC actually reads CPC.
Yes, sir.
If I record that, that will be an illegal order. CPC bars such mention that if the learned counsel is engaged otherwise, adjournment is not to be sought for.
Lordship, it is a health emergency. That is why on the last minute he had to.
That adjournment you have to file there.
Yes, sir, Lordship.
I can't become a doctor to certify your health emergency. Please appreciate that.
Grateful.
But if they will be grateful, I'm obliged that you are telling me grateful. Go to again. ଯେମିତି ଆପଣ ବି ସେମିତି ଆପଣ ଅର୍ଡରଟା ପଢି ନାହାନ୍ତି ବୋଧେ?
Yes, Lordship.
You should have said that the matter has been posted to so and so date. The learned counsel for the petitioner further seeks extension of the order. Stop. Order dated interim order dated 12-3-2026. Interim direction dated 12-3-2026. Stop. Accordingly, it is directed. The कितने तारीख को रख ले?
11-5.
अपन 4-5 को रखते. 4-5 को रखते हैं तो the matter shall be listed beyond the CP number 149 of 2023 shall be posted beyond 11-5-2026. As would be convenient to the learned court in season of the matter upon a prayer being made for the said purpose. Yes, next.
Grateful.
Yes, please.
Next
Next.
4-19-26. Page 5, 27-30.
22. Page 4. What's your name, sir?
Power is not approved.
Mr. Subhranshu Jena. 22. Mr. Subhranshu Jena for Aniruddha Das. For Mr. Aniruddha Das. For the petitioner.
Removal of defects.
The matter was presented before this court on 16-7-2021. As per SR dated 28-7-2021, defect was pointed, which has not yet been removed. On 21-11-20, the matter was listed before the Deputy Registrar into bracket Judicial, Lojima. So 3 weeks time was granted for removal of the defects. Thereafter on 6-3-2026, the matter was listed before this court and further time was granted, directing the matter to be listed today. Stop till date, the defect has not yet been moved. The learned counsel for the petitioner seeks further adjournment to remove the defects. As prayed for, the matter shall be listed in the week commencing 4-5-2026. Appearance lection. Yes, next please.
Page 5, 27-30.
Item number 30.
Yes, please.
No, I'm appearing on behalf of the opposite party number 4 managing committee.
Yes, please.
The institution I pray for adjournment.
So,
Counter.
you inform the other side because they
informed
will be
Mr.
waiting.
I have
Because
informed.
usually these matters reach around up 3:30. So
I have informed
can
Mr.
inform, yes.
Rahul.
और डेट कर देवे 30 टा.
I have already.
Absolutely. We can sing 11. Yes, please.
31.
Next page. 31. 31 टा डेट कर देले 31 टा डेट कर दियो.
Amnesty on the process.
Okay.
Wisdom ଅଛି 18/5.
And 32 to 37. 38 to 40. Call the list.
Item 1.
I'm for the petitioner, Your Worship.
Your name, madam?
Indira Priyadarshini Bose,
Miss Indira Priyadarshini Bose on behalf of
the petitioner.
Mr. Ratha.
Your Worship.
Mrs. Indira Priyadarshini Bose on behalf of the petitioner. Opposite party, Mr. Praraj is not there. Do you have any instruction?
No, Your Worship. We have sent him by post. We have sent him a letter. He has received, but he did not respond.
Just file that memo.
Your
और
Worship.
कागज दियो. Order dated 13/3/2026.
Yes, Your Worship.
थोड़ा आ जाओ डाके पढ़ो. इतना ऑर्डर कंप्लीट हुआ था. 13/3/2026 में para 1, para 2, para 3, 4. Repeat again. यहाँ पर है. By order dated 13/3/2026, the following was directed. Para 5, 6 and 7. Vote color. 1, 2, 3, 4 repeat है ना, that was 5, 6, 7. Opposite party now. For next chapter, that's the next one. It is submitted by the learned counsel for the petitioner, Mrs. Bose, that they have contacted the petitioner by sending a letter by speed post with registration, and proof of delivery. The tracking report shows that the letter has been received, but the petitioner remains incommunicado. Therefore, she pleads lack of instruction. The letter from the learned judge family court. Have you filed the memo?
I will find.
Okay. Only if lack of instruction, memo of date is filed by the learned counsel for the petitioner, which states thus. The memo shall be taken on record, scan copy be updated. For the letter from the learned judge family court Raukela, dated on 16/2026, addressed to the registry pursuant to the order dated 13/3/2026 indicates declares that on 15/7/2022, judgment has been delivered on 8 of 2009. The operative portion of the judgment, the said judgment, is indicated in the letter quote, dismissed on contest without cost. Pursuant to the order dated 13/3/2026, the learned judge Hon'Ble Puri has also intimated by letter dated 4/4/2026. It indicates CP number 93 of 20210. You लिख लें CP number. In CP number in कर दियो. In CP number इतने. Judgment has been pronounced by judgment dated 26/2/2011. Decree was drawn up, comma notified 11. Decree was drawn up, full stop कर दियो. ठीक है 7/3/2011 में. Decree was drawn up on 7/3/2011. The decree was signed and sealed on 7/3/2011. Stop. In view of the above, nothing survives for adjudication. The writ petition is disposed of. थोड़ा सा complete करो. সেটা দেবে ସୁବିଧା ଫାଇଲ ପଠେଇ ଦଉନାହାନ୍ତି କିମ୍ବା କାଢିଛନ୍ତି ସବୁ କଲ୍ କରନ୍ତୁ
Item 2,
Mr. Sudhir Chandra Mohanty for the petitioner. Yes, please.
My lord, the beneficiary and the RO may be allowed to be respondent as I file petition on that light.
Copy of the IR given.
Copy is given? Copy. Yes, I have given. This is the receipt. This is the receipt.
ଏବେ କପିଟା ଗୋଟେ ଆପଣ କପିଟା ଏକ୍ସଟ୍ରା ଅଛି
ହଁ
ଏବେ ଆପଣଙ୍କ କପିଟା ଦେଲେ ଦେଖି ପାରନ୍ତି
ଦେଖିପାରନ୍ତି.
Mr. Mohanty, can you open the paperless?
Yes, sir.
Flag white. Schedule ଅଛି last page mark ଟା ଜଣା ପଡୁନି
Schedule last. It affidavit, it says.
କୋଉ କାମ ଯେ
Amend the cost and
ହଁ ସେ କରିବେ आइए এটা হচ্ছে item 2 LAA 73 of 2022 IA 105 of 2026. The IA has been filed for repleting the requisitioning authority, public project proponent as respondent in the appeal. But the problem is that you never had them in the trial court.
This, if
Did you read
if
have you
the
read that Constitution Bench decision and High Court decision?
Supreme Court decision, it is if the arrow has not been made in Supreme Party in Supreme Court, it is rejected.
Which party?
No, the party should be, the arrow should be party in Supreme Court, High Court. And as it is not made the party in the High Court, so it is in Supreme Court, it is rejected. Petition is rejected.
ବୁଝିପାରିଲେ ଆପଣ ଏମିତି କଲେ କେମିତି ହବ କିଏ କ୍ଲେମାଣ୍ଟ କିଏ
Claimant.
ଫାଇଲ
Yes, Udit Narayana Singh.
ଆରେ ପାର୍ଟି ନା କୁହନ୍ତୁନି ସାର୍ ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ନହେଲେ ଓଡିଆରେ କୁହନ୍ତୁ
କଣ
ଆପଣ ଗୋଟେ କହୁଛନ୍ତି ଯେ if arrow is not impeded it is rejected ତାର ସେଣ୍ଟେନ୍ସ ର କିଛି ଅର୍ଥ ହେଇପାରିବ in a court of law
ହାଇକୋର୍ଟରେ ପାର୍ଟି କରି ରେସ୍ପଣ୍ଡେଣ୍ଟ କରିବା ପାଇଁ ଯେହେତୁ ପିଟିସନ ଦେଇନଥିଲେ ସେ ରିଜେକ୍ଟ ହେଇଗଲା ସୁପ୍ରିମକୋର୍ଟରେ ଗୋଟେ ପିଟିସନ ପାର୍ଟି କରିବା ପାଇଁ
ଆପଣ ଏତେ ପରିଶ୍ରମ କରାଗଲା ଆପଣଙ୍କ ପାଇଁ କନଷ୍ଟିଟ୍ୟୁସନ ବେଞ୍ଚ ଦିଆହେଲା ଡିସିସନ ଓଡିଶା ହାଇକୋର୍ଟ ଡିସିସନ ଦିଆହେଲା ତାକୁ ଦେଖିଲେନି I think जोटा से कॉन्स्टिट्यूशन बेंच जोटा कहिजे आपण सेटा ही बोधे आ गोटे प्रकार कहउछन कोटा रिजेक्ट हला कार पिटिशन एसएलपी रिजेक्ट हला कोन कहउछन कोन उदित नारायण सिंह कहलेनी तापर उदित नारायण सिंह कोन सुता
appeal
ठीक अछि copy of the IA the Learned Additional Standing Counsel seeks for another copy of the IA the Learned Counsel for the appellant submits that he has served he had served but he shall serve another copy para perusal of the IA ଏବେ ଗୋଟେ କପି ଦେଇଦେଲି
ଦେଇଛି ଗୋଟେ ଅଛି ମୁଁ ଜେରକ୍ସ କରି ଦେଇ
ଆଚ୍ଛା the copy of the IA is served in the during course of hearing the matter was had on 18/3/2026 Sudhir Chandra Mahanti appellant Mr. P.K. Mahanti AC respondent at paragraph 4 and 5 of the order dated 18/3/2026 4, 5, 6, 7 the following observations have been made 4 to 9 कर दो with just copy paste कर देले better to save time pass the Learned Counsel for the appellant submits that the appellant seek to implead the requisitioning authority of the project proponent as the respondent though they were not made parties before the referral court as is evident from the cost title available on record in LA number 16 of 1998 before the that was before the Learned Senior Civil Judge Kendrapada. Stop. The prayer for completion of parties is allowed. The Learned Counsel for the appellant shall necessary amendment of the cost title. Amended cost title shall be filed within
2 weeks.
Within 10 working days, copy shall be served on the Learned Additional Standing Counsel. Matters shall be listed for orders for under the same heading, heading of Chipra. Under the same heading, in the week commencing 27 na kon 27 hobo Mr.
4 5
କଣ ସେ ଆସିବେନି ଆଉ ଦେଖା କରୁନାହାନ୍ତି ଆସୁଛନ୍ତି appellants
ନାଇଁ
ଇଏ ଆଉ ଇଏ ତ ହେଇପାରିବ
ଚିଠି ଦଉଛି
yes next
Item 3,
ଆପଣ ଟିକେ ଆଜି ଦେଇ ଦିଅନ୍ତୁ ନହେଲେ କହିଲେ ସେ କୋର୍ଟରେ ଆପଣଙ୍କୁ ହେଲ୍ପ କରିବେ ଯଦି କହିବେ
ନାଇଁ କପି ଦେଇଥିଲି କପି ଦେଇ
sir.
କପି ଦେଇଥିଲି
Mr. Satpathy
Mediation was failed as per information. This matter relating to apportionment of compensation amount between the successors. Mediation.
अच्छा ठीक अछि फेल हैला अच्छा आपनकर जो लीगल है सक्सेसर्स क्लेमेंट्स है भी आपन कहतो without entering into that I mean respective it was considered in the section 18 reference
Section 18 reference has been adjudicated. 30 reference.
30 reference
30 reference. 30 reference order is under challenge in this.
so then it has to be
For hearing.
এটা কোর্টে রিপোর্ট আপন দেখলি
ମୁଁ ଯାହା information client local council ପାଇଥିଲି ଯେ fail ହେଇଯାଇଥିଲା ସେ report ବି ପଠେଇଛନ୍ତି
mediation was directed to be
in the district mediation center.
अच्छा अच्छा ठीक अछि अच्छा this was directed because they had Rayagada loko se difficulty of High Court as Mr. P.K. Satpathy for the petitioner. The Mukti is not today here.
ସେ online
ଖସି ଥିଲେ ଗଲା पोंगल थिला पोंगल की आडा थिला से जो फेस्टिवल थिला कोन छटा
school in Mukti apit.
it was a local holiday so P.K. Satpathy for the appellant respondent none the learned counsel for the petitioner appellants refers to the order dated 19/3/2026 paragraph 7 and 8 the report shall be obtained from the learned secretary district
Legal service.
DLSA Koraput. Copy of this order along with the order dated 19/3/2026 and forwarded to the learned DLSA Secretary DLSA Koraput. Stop. Awaiting response list in the week commencing.
They have submitted the report. Report actually.
Report के पाउन.
Again, ये अच्छी. Last.
मुझे आउट फाइल देखी.
क्या 2026 रे report अच्छी तो.
अच्छा लेटर.
Number 1733. Last. So failure on one member each of the appellant and respondent side are present. They were apprised the consequence of long-term litigation as well as changes of success or failure in the individual session held after
time ना. तो ऊपर पढ़ना पड़ेगा ना.
Being interested as mediator. Letter.
ना. Third sufferer.
Thirds. On dated 2 one member each from the appellant and respondent side are present. They were apprised of the consequence of long-run litigation as well as changes of success or failure.
Chances of
in the individual session held after half an hour recess, a joint session was taken up when both parties are inclined for a compromise, amicable settlement, but wanted some more time for discussion with the remaining member as well as with their advocate on the question of apportionment. As directed, this report, the report is to be submitted. There are further challenges.
So you have achieved it actually. सेठी सेटा हेलारु ही एक्चुअली इट कुड हैपन ऑल आसी दथान सेठी की भी तो आसलेनी जणे आसले
जणे गोटे मेंबर्स
ऑनली लेता पूर्वटा सेटा काट पटी ता पूर्वटा সেটা কাটନ୍ତୁ রিপোর্ট সালভিটা কাটନ୍ତୁ the Learned Secretary DLSA by letter dated 4/4/2026 closing the report dated 4/4/2026 of the trained mediator learned trained mediator district mediation center Koraput - Jaipur has সেটা ঠিক গেল কোন পড়িল has intimated the registry which is available on record marked as flag C. The report of the learned trained mediator is reproduced herein. सीरे देखिए अच्छी on 4/4/2026 up to neki mediation portion. Stop. The DLSA Koraput - Jaipur is requested to impress upon the learned mediator to take further mediation sessions as the first session has been very encouraging and the parties have shown sufficient indication for amicable settlement. Copy of this order shall be forwarded to the learned DLSA Koraput DLSA, Koraput - Jaipur JEYPUR. Awaiting response. The matter shall be listed in the week commencing. No.
11th May
ନହେଲେ 18 କାଢିବା
ତାଙ୍କର କି ହବା ପାଇଁ
18/5
ଫାର୍ଷ୍ଟ ୱିକ୍ ଅଫ୍ ମେ ବେଟର 4th May
4th ରଖନ୍ତୁ
ତାପରେ ସେଇ
11/5 କୁ ରଖନ୍ତୁ 11/5 କୁ 18/5 ରଖନ୍ତୁ
11/5
The matter shall be listed under the same heading in the week commencing 18/5. Meanwhile, the learned secretary DSA as well as the learned mediator shall take up the matter for arriving at a amicable settlement. Interim order has passed. Quebec hitla order
first order passed
interim order dated
23/8/24 first order. I number
23/8/24 shall continue till the next date of hearing. Yes, please. Next.
Item 7.
अरे ऑर्डर डका है नहीं ऑर्डर डका ये सब ओ अच्छा अच्छा सॉरी यस यस ये बाबू नेगेशन एबे ऑर्डर डका ही होची मते लाଗୁଛି ମଶା ଗୁଡାକ ବୋଧେ କାମୁଡୁଛନ୍ତି କଣ ଏତେ ମଶା ପଡିବ ସିଓଟେ ପଳେଇ ଆସୁ ये मिस्टर पंडा मानसुशेखर पंडा फॉर द पिटिशनर
Mr. Panda, my lord,
ଆପଣଙ୍କ ନାଁଟା ସାର୍
Sudhanshu
କଣ କରୁନାହାନ୍ତି
Passavarma.
ଆପଣ ଭଲ କରନ୍ତି ଆପଣ କଣ ପାସ୍ ଓଭର କରୁଛନ୍ତି ଠିକ ଅଛି ପାସ୍ ଓଭର କଲ୍ କରନ୍ତୁ
Item 9.
ପାସ୍ ଓଭର
Item 10.
स्पीच जेना थोड़े जियो मेंशन कर ले स्पीच जेना आइटम 10 स्पीच जेना फॉर द on behalf of Anjan Kumar Jena for the petitioner. इनकी लगे तो On 17th, after hearing the learned counsel for the petitioner at some length, the following order was passed. Para 2, 3, 4, 5. 2 to 11. 2 to 11. Today, the matter being in the list is mentioned by the learned counsel for the petitioner, and memo of date is filed, which states thus: the memo shall be taken on record, scanned copy be updated. Accordingly, the petition is disposed of.
Item 12,
Sahoo.
13,
Sahoo.
14,
ଟକା ହେଇଯାଇଛି ତାହେଲେ ଆଉ କଲ୍ କରନ୍ତୁ।
item 15,
14 ଟକା ହେଇଛି ତ
15,
15 ଫାଷ୍ଟ
16,
Mahanti, any difficulty passed over?
Your lordship, please.
No, no. You can't wait for the eternity. I understand.
Let it be passed over.
ବର୍ତ୍ତମାନ ପାଇଁ ହେଇଥାଉ ଦେଖିବ
नहीं कि सेट
ଆପଣ ଗଲା ପୂର୍ବରୁ କହିବେ
Order.
ବାହାରିଲା ମାନେ convince.
no problem.
Item 16.
May I please? I approve, my lord, condemn delay, my lord. Actual delay, my lord, it's
ଆପଣ ଟିକେ 16 ଟା ତ
my lord.
just look at the office note. Cause list ଅଛି ନହେଲେ ସେଇଠି କରିବେ ସେଇଟାରେ ସବୁବେଳେ କରନ୍ତୁ because that is now become the standard.
Yes.
I mean the usual thing. Order number 10-3 ଦେଖିଲେ 10-3-2026 ତାପରେ ଆପଣ ନୋଟଟା ସେଇ କଣ୍ଟେକ୍ସଟରେ ହେଇଛି referring to the office note regarding filing of type corrected content, it is submitted on 5/3/2026.
Yes, ma'am.
Registration verified proceed in the matter.
Yes, ma'am.
They have verified and they could not find. I don't know. So that is how they have stated no corrected cost title has been filed. Instead of filing corrected cost title, counsel for the appellant has filed IA number for correction of cost title of CP8 and deleted CMA number 41 of 2020. Record भूलभाल कौन मतलब typographical error फेर रहेगा ना
Okay, my lord, I would have the
अपन टी नहीं चेक करो सर अपन तेला पूर्वरु 50 टा की फाइल करथिले दीटा सीपी अछि गोटे सीएमए अछि
मैं एक्चुअली से टाइटल सीपी 53 टा लिखा हेतला प्राइव हेतला दीटा को टाइप
अपन टिके आपनकर क्लर्क को कहतु से बुझिबे दे शुड बी आल्सो सिंसियर
ओके
बारंबार फाइल करले दैट एड्स टू मोर कंफ्यूजन
ओबले टुडे मैं आईए टाइम
अपन टिके देखंतु भी आज गोटे रिपोर्ट अछि देखंतु रिपोर्ट टच करो बोल्ड रे अछि computer please report whether type corrected cost title has been filed during the period past appeal section लिखले after thorough verification made through CIs and CIS जो अपन डाटा additional periphery module it is found that no type corrected cost title has been filed during the period from 5/3 to 13 तो कोटी को फाइल वगैरह दे देखो learned counsel for the petitioner seeks further time referring to the order dated 16/3/2026 and the consequential office notes put up by the registry dated 16/3/2026. Listed for orders in the week commencing 4/5/2026. Yes.
17,
17 states appeal.
What is the note, Lok Adalat note? What is that?
Well, it's.
The order dated 10/3/2026.
Yes, that I am reading.
Order, order number 17, para 3, my lord has
Mr. Swai,
My lord.
should it be referred to Lok Adalat?
My lord, sir. I am ready with the written note, but I will need, my lord, that should be referred to local, my lord.
But can you work it out? Because
I
it
think,
becomes difficult
otherwise-
for the parties to understand also. These
Yes,
kind of
ma'am.
matters, you have to take the lead.
My lord, it's a nominal amount, 2 lakhs or something is a award. And state should not appeal, my lord, sir. There is a limit, delay in filing the appeal also. This should be settled with the interest and the solemnity of my lord, sir. Very nominal amount, Rengali project, my lord, also
Correct.
remember.
The appellant, the additional Mr. Prabhu Prasanna Behra, AC for the appellant. Mr. Ananda Chandra Swai for the respondent. The lauded AC for the appellant as well as the lauded counsel for the respondent refer to the order dated 10/3/2026. The stop. In response to the said order, the matter will be before the last Lok Adalat held on 14/3/26. Stop. It is submitted by the lauded counsel for the respondent that there is possibility of settlement of the matter in Lok Adalat as it involves a very small amount to be given to the land loser. Stop. The lauded additional standing counsel shall also obtain in the matter. Obtain instruction in the matter. The matter shall be placed in the pre-Lok Adalat conciliation session. A pre-Lok Adalat conciliation to be taken up. So, the registry shall do the needful. That was the High Court legal services to
I could.
Yes.
Much appreciated.
After the matter would be taken up in the pre-Lok Adalat conciliation at the level of or under the aegis of the High Court Legal Services Authority. The same shall be placed before the next Lok Adalat. Copy of this, the parties shall have liberty to proceed on the basis of the copy obtained from the official website of this court.
Yes, ma'am.
Yes.
Much appreciated.
Item 18.
Samantra,
On behalf of Mr. Samantra,
sir, I forgot your name, sir. Sorry.
Samantra Swai.
Mr. S. Swai on behalf of B. Samantra for the
My lord, withdrawal memo is there, my lord, final display.
ठीक है. Appearance लिखिए. Mr. Prabhu Prasanna Behra, standing counsel for the respondents. Author Mr. Behra, you were there.
Sir.
Apna
Sir, yes, I was there, but my file.
apna na अछि to?
Yes, madam. It has been allotted.
Correctly reflected. Na
Yes.
appearance bhule le.
No, madam. Yes, it is there.
Apna टिके paperless से देखी दियो तो.
Yes.
Memo is at flag N.
Yes. Yes.
The court date bench by order dated 11/8/2025 had observed thus, after hearing the learned counsel for the appellant as well as the learned AC for the respondent, memo dated 12/8/2025 has been filed by the learned counsel for the appellant, which states thus. Literally, memo is filed, which is on record, and states thus. Which is on record marked at flag N, flag dash capital N, and states thus, quote for the the memo, in view of the above, the appeal is disposed of. Yes, please. Next.
until
My lord, on behalf of Devashish Tripathi, I am appearing for the petitioner. Neither in this matter, no, neither AD nor the copy is written.
Wait karibe.
ଆଉ ଗୋଟେ ଜିନିଷ
ठीक ଅଛି ଆପଣଙ୍କ ନାଁ sir?
ହିତେଶ କୁମାର ସାହୁ
Power nahi.
No, my lord.
Mr. Hitesh Kumar Sahu on behalf of Devashish Tripathi for the petitioner. Item 19. Notices have been issued pursuant to the order passed by the author notice afresh ଦେଇଥିଲେ
2 times ଦେଇଛୁ
ଆଜ୍ଞା
2 times ଦେଇଥିଲୁ
the last order ଟା କେମିତି ସବୁବେଳେ order କୁ refer କରିବି that is how you
7/3/20
20 ମସିହାର ବହୁତ ଦିନ ହେଇଗଲାଣି ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ପାଇଥିଲା I think 20 ମସିହା ପରେ ଆଉ ନୋଟିସ ଯାଇନି 12/2/2020 Mr. Behra order number 5 is already 6 years. Can you look at order number 7, Mr. Sahu?
Yes. 20. The matter has been registered for the order including neither AD nor under notice written from the sole OP. The petitioner husband, the marriage is before the court seeking the transfer CRP number 124/2018 from of the London Judge, Family Court, Bhubaneswar to the court.
ତାପରେ next ଟା ପଢନ୍ତୁ flag P. You should never miss an opportunity to prepare. Flag P ପଢନ୍ତୁ. এটা P touch करो.
Insulator notes of the dismissed.
So nothing is there.
Yes.
Appearance section. Mr. Prabhu Prasanna Behra, am I rescued? You have to be. Because I don't know whether I will at times. So, opposite part there like that, am I Mr. Prabhu Prasanna Behra, am I rescued? By order dated before 3/2026, the following was observed. None appears for the opposite party. The learned counsel, Mr. P.P. Behra, appears as amicus. Being present in the court, is requested to go through the records. He renders assistance to the court as amicus. Stop. The office note put up by the registry indicates that there is no neither AD nor undelivered notice returned from sole OP, which was also noted in order dated 26/3/2026. Para. The learned judge, Family Court, Bhubaneswar by 13/3/2026 has intimated that 13/3/2026 addressed to the registry of this court has intimated that the criminal proceeding number 154/2018 has been dismissed for deferred video order dated 05/10/110 5/10/2023. Stop. The petitioner has prayed for transfer of the CR.P. number 154/2008 from the Court of Learned Judge Family Court to the Court of Learned Judge Family Court, Hyderabad. After dismissal of the CRP on 5/10/2023, CR.P. Nothing survives for application. The petition is disposed of. Yes, next.
Item 20,
Dinand. Pass over karo.
21,
Mr. Praharaj has not come. The second non-appearance.
23,
21 road. Pass over it already. I put list each. 21.
May I please, Lord?
21 ଆପଣଙ୍କର sir.
No, sir, 23.
Just give me a moment. 21. None appears for the petitioner when the matter is called. None had appeared on 10/3/2026 when the matter was listed. Registry was requested to intimate the order as well as the date of listing to the learned counsel for the petitioner. Stop. Office note put up by the registry. It 6/4/2026 indicates that on 23/3/2026, the learned counsel for the petitioner was intimated over phone regarding the date of listing. So, the petition has been filed seeking revision of the order dated 5/2/2020 passed by the learned judge Family Court Baripada, Mayurbhanj in CR.P. number 62 of 2018. The said CR.P. was filed by the wife in the marriage under section 125 of CRPC. Into brackets, since repealed and substituted by the material provision contained in section 124 of PMSS 2023, bracket closed, seeking monthly maintenance. The petition was favored. Directing payment of rupees 4,000 per month from the date of the order, that is 5/2/2020. The petition was filed defective as pointed by the stamp report dated 19/3/2020. Thereafter, on 8/11, the petition was listed before the deputy registrar into bracket judicial, lodgement. Stuff. 3 weeks time was granted for removal of the defects. The defect is the certified copy of the impugned order is not furnished. So, in absence of the certified copy of the impugned order, the further staff reporting could not be made, and such defect is also cannot be condoned by this court. Stop. The efforts of registry to contact the learned counsel for the petitioner has also not yielded any result, as the learned counsel remains absent. Stop. The petitioner is also absent on call. Stop. In view of the above, the petition is dismissed. Copy of this order shall be forwarded to the learned Judge Family Court Baripada to be kept in the records of CR.P number 62 of 2018. Post of by order dated 5/2/2020. Yes, next.
Item 23.
Yeah,
Yes, please.
there is a delay of 32 months to for this revision petition, Lordship. As the mother of the applicant was suffered.
Sir, before you argue on merits, if I am convinced, then I will condone the delay.
In this case, my lord, the learned court below has granted 10,000 rupees per month to the respondent, Lordship. In this case, my lord, respondent examined herself.
Your name, sir?
My name is Shivananda Das, your Lordship.
Mr. Shivananda Das, SIVA.
SIBA, B for Bhubaneswar.
Shivananda Das for the petitioner, opposite blank. Yes.
And believing the version of the respondent, Lordship, he has passed the order, Lordship.
So respondent is to be disbelieved by the court. That is your
No,
first
no, no,
contention.
no.
So then why you are making that such condition? We are not in a casual conversation. You are challenging a order by the court of jurisdiction. That by believing the respondent, the order has been passed.
Believing the documents and the versions, Lordship.
Yes. So now you have to show that you disprove those documents before the trial court.
Yes, my lord.
So show that. So your written statement first. Which page? अरे ब्रीफ धरनांती कोन ओल्टुचंती कोन सर
नहीं सर ब्रीफ भाग
आगे
अच्छी सर
अरे मो पाखरे कोड आसीबो मु कोन आपण चेंबर जिबि ना कोन
नहीं सर
कोन करछन अरे प्लीज रेफर टू द ब्रीफ every day I find this very I ask that for some document you start searching leaving your brief
issue number 3 your lordship kindly have a glance
आपण जोटा आर्ग्यू करछंती substantiate by showing that you took that plea in the written statement and what was your deposition and evidence.
Lordship में come in some other date I will
date आएगा कौन होगा तो किसी नहीं है IA number 446 of 2022 with RPFM 348 of 2022 आपण जेते बडे ग्राउंड रे जो ग्राउंड रे चैलेंज करिवे you must look at your seasoned and too senior I mean to have that kind of approach. IA number 446 of 2022 with RPFM 348 of 2022 है ना item कितने का डेटा होता है item 23 the petitioner husband in the marriage is before this court seeking revision of the judgment dated 14/3/2019 judgment and order dated 14/3/2019 passed by the Lord Family Court Bhubaneswar in criminal proceeding number 215 of 2016. Well, they submitted that the Judge Family Court has erroneously relied on the evidence adduced by the petitioner in the petition. Stop. The petition was filed by the wife in the marriage under section 125 of CRPC into bracket since repealed and substituted by the materia provision. Section 144 of Bharatiya Nagarika Surakha Sanhita 2023 bracket closed seeking monthly maintenance of 20,000. The Learned Judge Family Court has recorded evidence as presented before it by the wife as PW1, opposite party as OPW1, 3 exhibits were marked on behalf of the petitioner and 2 exhibits were marked on behalf of the opposite party husband. Stop. The direction of payment of the maintenance is at rupees 10,000 instead of rupees 20,000 as claimed from the date of the order, that is 2019. The learned counsel for the petitioner submits that notices may be issued for condonation of delay. Stop. In considered view of this court, before issuance of notice for condonation of delay, this court has to hear on the regarding the prima facie merits of the case. Stop. In view of the contention that the learned judge family court has incorrectly relied on the evidence of the petitioner wife, the learned counsel for the petitioner was asked to place on record the written statement of the opposite party husband as well as his depositions, and whether any endeavor was made by the opposite party to disprove the evidence presented by the petitioner. Stop. Learned counsel seeks and has adjournment to address further on the above issue. List 11/5/2024. You also examine the law, scope of revision, to what extent by pleading that. Please go through that.
Yes, madam.
Yes, next.
Item 24.
Judgment. My lord, here the worst husband also before my lord that in his after his retirement and he has been physically handicapped, unable to move because he has sustained severe injury.
Sir, the problem is that it is not a speech. Just to
Sir, I am telling the fact on the record, sir.
Sir, kindly the learned counsel for the petitioner submits that the husband has retired, is physically handicapped, has suffered injury. His request to refer to the written statement as well as the evidence presented before the learned judge family court.
Sir,
please place it.
Sir, the learned judge family court.
Sir, kindly place the written statement.
Sir.
Where you have stated all this.
The written statement, sir. No. Sir.
The statement is the narrative presented before the court in the revision application is a question of is a matter of pleading and evidence. So, Aji Habani sir.
1 minute, sir. 1 minute.
Who page re achi sir?
Na page ko mu dekhi dଉଛି ଟିକେ ଖାଲି sir ଟିକେ ଆପଣ ନାଇଁ ସାର୍ ଆପଣ ୟୁ ଆର୍ ଭେରି ଜିନିୟସ୍ ମୁଁ ଜାଣିଛି ଆପଣ ଭେରି ଜିନିୟସ୍ ୱିଦିନ୍ ନୋ ଟାଇମ୍ ଓନ୍ଲି ମାଇ ପ୍ରେୟାର ସାର୍ ଇଟ୍ ଇଜ୍ ଦ ଡ୍ୟୁଟି ଅଫ୍ ଦି ଫ୍ୟାମିଲି କୋର୍ଟ ଫ୍ୟାମିଲି ଜଜ୍
କହିବେ
ଟିକେ ଖାଲି ହାଇକୋର୍ଟ ଜଜ୍ ସାର୍ ଟିକେ ଖାଲି କହିଦିଏ ଟିକେ
ଆପଣ ଟିକେ ଘରେ ପ୍ରିପେୟାର ହେଇକି
ଯେତିକି ସାର୍ ଖାଲି କହିଦିଏ
ଷ୍ଟେଟମେଣ୍ଟଟା ଟିକେ ପଢନ୍ତୁ ସାର୍ ଆଇ କାଣ୍ଟ ୱେଟ୍ ଫର୍ ୟୁ
ସାର୍ ଠିକ ଅଛି
ଆପଣ
ଅନ୍ୟ ଗୋଟେ ଡେଟ୍ ରଖନ୍ତୁ ସାର୍
ଏଇଟା ଲେଖିବା ପୂର୍ବରୁ ଏଇଟା କମ୍ପ୍ଲିଟ୍ ହେଇଗଲା ତ ତା ପୂର୍ବରୁ ଲେଖିବେ.
No compromise was made between the party. No attempt also made by the judge family court. Compromise the first of all. Suppose the husband is interested to take back our wife.
Provision nahi sir.
No, maintenance provision kotha nahi. Suppose if there is a compromise possible, sir.
Provision nahi sir.
I will sir. Musa
I will mix up kar dele. Eta hochi apan ko family court kani bharti kar dele 125 re. 125 re compromise nahi. The reason being, starting with Justice Krishna, the matter is very clear. It is a 15(3) provision.
Sir.
Which 15(3)? Yes. Padunanti.
No, she is not family.
15th of the Constitution of India.
Oh, sorry.
ଆପଣ ତାକୁ ଆଣିକି ଆପଣ ଫ୍ୟାମିଲି ଭିତରେ ଭର୍ତ୍ତି କରି କମ୍ପ୍ରୋମାଇଜ ଯାଇକି
That is the sir, all the proceeding, that is maintenance proceeding, whatever the proceeding the husband, sir.
ଆପଣ ମତେ ଇଲିଗାଲ ଅର୍ଡର ଆପଣ ମତେ କମ୍ପେଲ କରିବେ କେମିତି ହବ?
ନା compel କରିନି, that is my submission, sir. Subject to acceptance.
ଆପଣଙ୍କର ସବଜେକ୍ଟ ଟୁ କେମିତି ଆକ୍ସେପ୍ଟ ହବ?
May not be accepted, but that is here.
ଆପଣ ଦେଖିବା ଦରକାର ସେକ୍ସନ 18 125
ଆଜ୍ଞା
24 ଏଥିରେ କୋଉଥିରେ କମ୍ପ୍ରୋମାଇଜ
ଅଛି sir. I am supported by the many decisions. I brought it all those decisions. Sir,
ଗୋଟେ ডিসিশন
David sir, go for the
ডিসিশন পଢିବେନି টাইম ইন রিডিং অলসো
ঠিক আছে sir, ମୁଁ ଆପଣଙ୍କୁ
টাইম
ଆଜ୍ଞା
রিড ବୋଥ
ଆମର own high court decision, sir, our high court decision.
What has been followed by
Justice K.R. Mahapatra's decision. I was arguing the one matter was set back to the family Nayagarh. First,
maintenance dava pai bilkul nahi sir. So there is now the law is well developed.
Sir.
ଆପଣ ଯଦି ପଇସା ନିଜେ ଦେବେ କି କୋର୍ଟ ଦେବେ, that's a different thing. ସେଟା ସରିଲା ତା ପୂର୍ବରୁ ଲେଖିବି as no. The matter is was presented before this court on 9/3/2023, and on the 23/2/2026 it was adjourned as no one had appeared. On 11/3/2026, as no counsel appeared, the registry was requested to intimate the learned counsel for the petitioner. The efforts of the registry has yielded result. Paper liquid is submitted by the learned counsel for the petitioner. Yes, next.
Please, sir.
Keep date color.
What a ticket.
The learned counsel 6 and has adjournment. List in the week commencing 11/5.
Please, sir.
25 May, please, my lords, I am appearing through virtual mode.
Yes.
May I please?
So kindly go through the order dated 5/3/2026.
Instruction to take the instruction.
For the petitioner, Mr. D. Mahapatra, for the opposite party. The hybrid mode, the learned counsel for the opposite party being present in the virtual court, High Court of Orissa, Khurda at Bhubaneswar. This is arguments. The learned counsel for the petitioner seeks further adjournment. The learned counsel for the opposite party refers to the order dated 5/3/2026. The matter was heard at length and the issues were recorded in detail as reflected in the order. To grant further opportunity to the petitioner, the matter shall be listed for orders. We commencing 4/5/2026.
My lords,
yes.
One submission, my lords. Your lords, we just have a glance to the last order, my lords. If your lordship remember this matter on 25/3/2026, on that score they had taken time, and because of the interim order that is operating, my lords, they are just adjourning this matter, my lords. If your lordship remember, the entire proceeding has been stayed in this case.
May I please, my lord? In the meantime, divorce petition allowed, and there must be some alimony relating to the divorce petition. I am ready to pay the alimony.
Don't make a, whenever you are not prepared, don't expose yourself.
No, last occasion my lordship told to take the instruction how my amount I will pay.
Nothing.
That instruction I have not taken.
Sir, nothing, madam. If
Instruction.
the learned counsel for the petitioner is made aware of the order dated 25/3/2026, paragraphs 2, 3, and 4, which are reiterated, which are reproduced here. But shall be listed for orders. Yes.
26.
4-5, yes. So
27.
Item number 27, I'm appearing for the respondent number
26.
27.
Suppose. This Mr. Chenna usually remains present in the VC. So you can you please wait?
Lords,
If it is passed over, would you wait or?
Lords, I may wait, Lords, but they have not served me a copy yet, Lords.
So they have to be there actually.
Lord. Oh, bless.
Give them some time if anyone comes. Then call the next.
20.
This petition filed by the petitioner for restoration of read petition number 10693 of 2003, which was
You are appearing 28.
Beg your pardon, my lords. I'm appearing on behalf of Sri Saswat Das. Is engaged in another court, my lords. Short adjournment if
Mr. B. Bishwa for the petitioner.
Siddhant.
Power here.
Yes, my lords.
Siddhant Das for on behalf of Saswat Das for the opposite party. One and three corner. Radha corner. OP1.
1 to
1 and 3 same.
ତାହେଲେ ସେ appear କରୁଛନ୍ତି but ଏଥିରେ ଲେଖା ହେଇଛି 1 and 2. In my brief it is written as 1 and 2.
So 3 is same. University representative through register.
The learned counsel for the party 6 adjournment. 6 short adjournment. The matter shall be listed in the week commencing. 11-5. That's listed for orders. Yes. Yes, next.
29.
My lord, this is transfer matter. Notice.
Author notice nebe. Insufficient address.
କିନ୍ତୁ ସେ ବର୍ତ୍ତମାନ ହାଇଦ୍ରାବାଦରେ ରହୁଛି ସେଟା ମେନସନ ହେଇନି କଷ୍ଟ ଟାଇଟେଲରେ ଆଡ୍ରେସ ଦେଲେ ଯୋଉ ଆଡ୍ରେସ
ଆପଣଙ୍କର ନନ୍ ସର୍ଭିସ ପରେ ଏଟା ଫାଷ୍ଟ ଟାଇମ୍ ପାଇଁ ଆସିଲା
ଆଜ୍ଞା
ଏଟା ମିଷ୍ଟର କଣ ମିସେସ୍ Cabery Mahanti MS Cabery Mahanti for the petitioner opposite party flag office note put up by the registry indicates that notices were issued pursuant to the order passed by the coordinate bench dated order dated 3/12/25 passed by the coordinate bench. The notice has been returned unserved, returned undelivered with post endorsement, insufficient address. Stop. The learned counsel for the time to recover the present correct address and file the requisites. Stop. Accordingly, for the 2 weeks time, for the 2 weeks time granted for filing of requisites in the present correct address. Upon filing of the requisites, notices shall be issued afresh to the opposite party. Stop. Only copies of the requisites shall be utilized.
My lord, IA 440 of 2025 stay. Interim order continue.
The interim order dated 3/12/25 shall continue. Until the next date of hearing. List after SR, liberty to mention. Yes, next. ପାସଓଭର ଯୋଉଟା କହିଲା କି ଅଛନ୍ତି କି ଆପଣଙ୍କର କେତେ ନମ୍ବର ସିରିଏଲ ଡାକି ଦିଅ
ପାସଓଭର ଆଇଟମ 7.
ହଁ ନେକ୍ସଟ କରନ୍ତୁ ସେ ନାହାନ୍ତି ନା
ପାସଓଭର ଆଇଟମ ନାହିଁ
ନେକ୍ସଟ
ପାସଓଭର ଆଇଟମ 12. Password item 13.
13 minutes visual also.
Sarada Das for the petitioner. So Sarada Das for the petitioner. Yes.
My lord, this transfer petition is filed to transfer under section 24, transfer the CP number 83 of 25 filed by husband of this petitioner under section 9 of Hindu Marriage Act. My lord, the petitioner is staying at Bhubaneswar and the opposite party is staying in Jaipur.
What is her intention? She wants to resume the matrimony or not?
No, my lord, because she has been tortured like anything. One CRP is 2008 is
How many
filed.
cases she has filed against the husband?
One CRP number 208 for maintenance has been filed. Since the opposite party failed to pay on maintenance, she has filed an execution petition and the opposite party never appeared, my lord. Then one city case is also filed by state, my lord. Since she has filed an FIR on the basis of the city case which is also pending before
FIR कौन पाई?
FIR इतला
498
my lord 498
ଆଉ କଣ କେସ୍ କରୁଛନ୍ତି? DV କେସ୍ ବି କରିଥିବେ?
नहीं DV केस है नहीं ये तीनटा केस में and say he
ତିନିଟା କେସ୍ କଲା ପରେ she is pleading to be hapless, so the petition should be transferred.
my lord, and the petitioner is an heart patient, my lord. Every time she needs
Heart patient को आएगा कोई special court करा है नहीं पर्जन. Vulnerable witness है जी.
but
If I pass that order, that petitioner is heart patient, the court has to go to her house. Can it?
no सेटा हम कोनी but
So the way has she come to High Court, she can engage you in High Court, or the petitioner is going to High Court.
no not
You must understand, you make a submission which is legally nuanced.
yes, my lord.
For heart patients, there is no provision in CPC that there will be a special court. I mean, the law has evolved. We are now having vulnerable witness deposition center. If somebody is hospitalized, there can be a commission of anyway.
My lord, not a single penny of maintenance has been paid.
How can it be adjudicated in the TRPC?
No, I am saying
Cannot.
that since she has no income, she is a patient and
For no income patient, I cannot attribute it to the court at a CORAM.
Since all
Suppose this court, High Court observes that the person is not getting any amount, heart patient, the court is not good.
No, court is not.
You must understand the context of the order.
I have a judgment of Supreme Court, my lord. I have a judgment of
Read that where it says that for heart
Yes,
patients
well,
and
not heart, but
so then don't make
but it is there that it is it is
like you are reading judgments. I do read judgment. There is no such judgment
my lord,
because you are filing 3 actions
yes, my
against
lord.
your husband, and if he files section 9, it has to be transferred where you wish.
My lord,
Have you
just
read
to-
section?
just to
Have you read section 19 of the Hindu Marriage Act? Section 9 of CPC.
Section 9 of CPC, my
There
lord,
is no such
jurisdiction.
provision. There is no such provision where after filing 3 cases of wife, because he is a heart patient and is not getting any money, the husband cannot file section 9 or wherever.
Yes,
it is.
he can file. I have no objection whether the husband,
There is
but
that single line where this court has said that the convenience of the wife is to be
yes, my
referred.
lord, it is there.
Section 19 is very interesting. Section 2, look at section 24 of CPC.
Yes, my lord.
Anyway, you take notice.
Sorry, my lord.
Because you take notice, that much I can do, because 24, the language is very interesting. Anyone can file, but the court has to look for convenience of the parties. It is in plural.
But
That cannot, I mean, no, there is no decision which has interpreted that it has to be the convenience of one party.
but why convenience to be considered?
Where,
my lord? I have a judgment of
can you read that?
that is it is may I read if you
It's the facts.
that is also transfer petition under section since he was in saying in Chennai and it's the petition the opposite party is bill and it is the petition is transfer.
Can you read? Can you read the
That
what
is,
are the
it is-
facts?
that
What is the
particular
reason for transferring?
paragraph 8 of their judgment.
Put it ଆପଣ ପଢିବେନି ମତେ ପଢିବାକୁ
Yes, my lord. That is also filed under section of conjugal rights. So restitution of conjugal rights. Paragraph 8 and paragraph 9 are important. my lord.
କୋର୍ଟରେ ଟିକେ ପଢିବେ that is much more important.
8
4 4 4 muted ही पढ़ो तुनी कोर्ट रे muted ही पढ़ले
The appellant is Chennai and she has also filed 2 cases. HMP number 174 on 2021 has been filed by her before the family court at Chennai against her husband for restitution of
so in your case who has filed restitution?
No, my case her husband filed.
So that is clearly distinguishable.
My lord,
If you apply this principle, because the wife has filed section 9 at Chennai, the case has to be at Chennai from transferred from Vellore.
My lord.
So that logic is to apply, then the husband has filed the section 9.
My lord, just to
And you have filed 3 criminal cases.
My lordship said, since
You must understand, your argument is on the face of it is wrong. Section 9 application does not prohibit grant of maintenance.
my lord,
By filing, suppose as a legal strategy, you file a section 9 petition to deny maintenance, there is no such case law. Or section is not there.
But
maintenance is filed in 125.
125 says
Section 9
we
is not
fail
necessary.
provide if fail to give any maintenance, there I find
For that, which is the provision?
No, execution case also I have filed.
Not execution 125.3.
But
125.3 doesn't speak about execution. When you do not read the entire case, that is how I was asking you that, in fact, this is a case the wife has filed a section 9 application. That is how the court has considered. But has filed a 498A case. 498A is to be tried by a sessions court.
My lord.
So can he take up the this section 9 application?
Sorry, I did not get much. Sorry, my lord. It's a
Section 9 application filed by husband has to be taken up by the family judge.
yes.
So can the sessions case and the section 9 application taken up together?
No, my lord.
So that you must understand. When section 9 application is filed by the wife,
Yes, fine.
it is pending in Chennai. The wife stays in Chennai. Then the husband files another case at Vellore. What is the case at Vellore? 13 or another case?
That is Vellore case is my lord.
And before I read this, I have passed many orders where cases have been filed. Here, section 9 is filed by wife in Chennai. Section 125 is also filed by wife in Chennai. What is the case filed at
Vellore, my lord. That is TRCMP, that is 473 of 2000. That is respondent file FCOP under section 125 of 2020 of before family 120.
সেটা আজ্ঞা wife file করছেন
It is respondent লেখাইছি এটি the respondent file aforesaid FCOP.
So 125 was filed by the husband?
No, my lord. Before family court, that is FCOP. I don't know the exact nature.
ଏଥିପାଇଁ ସେଟାକେ ଆପଣ nomenclature जो HMOP HCOP ପଢିବେନି ସବୁବେଳେ section ଟା ପଢିବେନି.
That is of that is not detail has not been given, but section 9 the paragraph 9 of this judgment clearly say that it is the wife continues.
Since you have not read say paragraph 4 and 5, section 9 you are reading out of context.
What your lordship
Section 9 section 9 is filed at Chennai. 125 is filed at Chennai.
Yes.
Who says that 125 you are not getting it? It is
No,
at
that
top
is
of the
case number. That is case.
No.
My lord, that is FOC.
Not my lord, ଆପଣ ଏତେ ଜିଦ୍ଦି କଲେ କେମିତି ହେବ? ଆପଣ ପଢୁନାହାନ୍ତି ଅନଉନାହାନ୍ତି. Page 2 ର first line ଟା ପଢନ୍ତୁ. କଣ ଲେଖା ହେଇଛି?
The appellant in her petitioner filed under section 9.
ଆପଣ ମିସ୍ ବି କରୁଛନ୍ତି.
Page.
ଆପଣ କପି ବାହାର କଲେ ଆପଣ ଜାଣି କରୁନାହାନ୍ତି.
Your lordship say page number 2. Page.
First line କଣ ଲେଖା ହେଇଛି? appellant ଲେଖା ହେଇଛି.
Page number 2 is there. Appellant in her petition
ତା ପୂର୍ବରୁ କଣ ଲେଖା ହେଇଛି?
family court at Chennai for maintenance under section 125 of
କେତେ ବା ଲାଗିଲା ସେଟା ଆପଣଙ୍କର? My lord ଚଲେଇଲେ. When section 9 and 125 both happening in Chennai, so that is how the High Court has directed, Supreme Court has directed for transfer. And please mark, even Chennai High Court did not grant it. Section 24. In your case, you have filed some other criminal case at 25.
Yes, ma'am.
There is
Criminal-
and section 9 has been filed by the husband.
Yes, ma'am.
And if you read here, you will find that you have filed more number of cases than your husband has filed against you.
Since I have been
Anyway,
prepared and I have
So you must understand while reading a case and presenting a case, you must prepare for get the basic foundational facts.
but
ଆପଣ କେସରେ ଆପଣ ସେକ୍ସନ 9 ଫାଇଲ କରିନାହାନ୍ତି ଆପଣ ଫାଇଲ କରିନାହାନ୍ତି ଆପଣ ଫାଇଲ କରିଛନ୍ତି ହଜବେଣ୍ଡଙ୍କ ନାଁରେ
my lord.
ସେ ଟ୍ରାଏଲ ହବ 498 ଆଉ ସେକ୍ସନ ଆପଣଙ୍କର 125 ଏକାଠି ଟ୍ରାଏଲ ହେଇପାରିବ
ଏକାଠି ନେଇ but since all
କେମିତି ହବ
the cases are pending.
how the court will direct और ସେଇଥିରେ ଯୋଉ ଡିସିଜନ ବି ପଢୁଛନ୍ତି ସେଥିରେ ଲେଖା ହେଇଛି ଯେ that both the cases should be taken up at one place. And you have not thought about it that what case has been filed by the husband.
No, I have also cited one judgment in my petition, my lord, in my petition also. That is,
The petitioner wife is before this court seeking transfer of the application filed by the husband in the marriage under section 9 pending before the learned judge family court Koraput. It is submitted by the or being asked, it is submitted by the learned counsel for the petitioner wife that the wife has filed as many as three cases against the husband. One of them being under the arising out of FIR before the Mohila police station, Bhubaneswar. Number 2021. She has filed CR criminal proceeding number 152 of 2021 before the learned judge family court Cuttack claiming maintenance. She has filed another case seeking maintenance. That is criminal proceeding number 208 of 2022 before the learned judge family court. Bhubaneswar. It is submitted by FIR FIR.
only one FIR I have lost and one
Submitted by the learned counsel for the petitioner that the FIR lost was under the provision of section 498A of
490 along with other allied offenses, my lord.
Inter alia section 498A of IPC since repealed and substituted by pari-materia provision contained in. Sorry, again. Who upon 144? Para. Then if I refer to the Supreme Court decision, your case falls apart. The case you are relying on, section 9 by a wife, 125 filed by wife at Chennai and the husband files a case at Vellore. Most likely that would be a matrimonial action because I didn't want to spend time.
Your lordship see my petition.
Anyway, leave it.
If your lordship see my petition, I have another judgment I have quoted, my lord. That is.
Your problem is that you are quoting judgments where even knowing the facts. The court has to assist you to know the sections when it is filed.
Yes,
that you have to avoid. Why should you expect the court to read and assist you?
my lord, I'm sorry.
You should be
For
sorry
that
for that.
aspect,
I
I'm
don't
sorry.
expect any. It is you who is to educate the court.
Yes, ma'am.
Order. For a notice be issued by speed post with registration and proof of delivery, requisites for issuance of notice be filed within 7 working days. Returnable date be fixed to January 5, 2024. The matters shall be listed in the week commencing 11/5/2024. Type न करी कर दियो तो 7/5.
My lord, the only.
80/2026. Had Lord counsel for the petitioner. Issue notice as above. Except one set of process fee as well as postal liquidations along with the petition. The next date of listing, the returnable date as well as the date of listing shall be as directed above. Or as an interim measure, it is directed that the Lord Judge Family Court, Koraput, Lord Judge Family Court, Jaipur at Koraput, shall adjourn the CP number 83 of 2025 beyond a date. Beyond the date to beyond author of 5/2026 as would be convenient to the Lord voting season of the matter upon a prayer being made for state purpose.
Pachor item 15.
Mr. Bhavani Shankar Panigrahi for the petitioner, Mr. Prem Kumar Manthi for the opposite party. The matter was passed over and called against. The Lord counsel for the petitioner is heard. Yes, Mr. Panigrahi.
The petitioner challenges the shortlisting of the private individuals to be appointed as dealer under the PDS Control Order 2016 Miller in violation of the mandatory provisions.
So what interim order you are seeking? Notice can be issued because you are seeking alleging non-compliance of the statutory provision.
Interim order not to give this notification. Not
That
to
cannot
give,
be.
give it.
Final, then it is final order. And it is PDS.
So,
Suppose they are not, then you have to tell the court what is the consequence of not giving it to this list.
but this is the shortlisting of the candidates. They have not appointed, they have not issued
Whatever.
the order of appointment.
So that you have told twice. I don't think I am that difficult in understanding. You have to, I am asking you what would be the convenient consequence to the shortlisting.
But in the
Because
event,
they are yet to be heard. They are yet to be heard. Notice you have to make them parties. To save time, because ultimately your objective is to
Lordship
solve that.
issue notice, let them give their
And where are they? Where are they? The parties are not being made.
They have not been made parties
It
because
cannot be.
but it is only against the government.
It is like a appointment.
Yes.
Suppose you are challenging a selection list leading to appointment in any post. The person who is to be dislodged by you has to be given notice. Now you have to say that now suppose they have been shortlisted. So a right has accrued in their favor.
I could follow you, Lordship.
No, you are definitely have to follow. You will follow.
No, I could follow.
Because the party
because this is not the final allotment, they have not been.
कब उंगली करना है आपको सोचना है. आपके साथ कोर्ट जाके उंगली करेंगे तो नहीं हो सकता है ना. ये महासागर किसी कामों नहीं होते. The petitioner doesn't have any work. He is a busybody. He is not serious in litigating. If whoever he is, if he wants to challenge, let him challenge. You are challenging somebody's selection. You make him a party. That itself makes it clear that what is the exact intention of the petition. Because he is serious litigant. He doesn't have a stake actually. He might have been motivated by someone. He doesn't understand. Perhaps he doesn't understand what he is doing also. Apart from having a good counsel, he has done nothing.
It is only the selection.
This is a half-hearted measure. There is a select list. Don't make the persons a party. Make the authorities a party. Court will definitely ask that what is this? You are not making the persons who have been shortlisted a party and only making the authorities a party. Because it is their selection you are challenging. Yes. Then PI file PL by
PL.
court of PL no that PL this court doesn't have jurisdiction.
No, PL, not PL.
But it is almost like a PI. Okay, कितना है लग? बहुत ही गलत बैंक पर कितना होता है? Stated to Bhavani Sakat Panigrahi for the petitioner, Mr. Prem Kumar Mahanti, additional standing counsel for the opposite parties. और इम्प्यूट नोटिफिकेशन ना कोटा 13/3/16
मतलब
the petitioner
13/26
petitioner has stated to be a resident village of Borana, the district of Jajpur. He challenges appointment of dealers oblique retailers.
shortlisting of the candidates. They have not been appointed.
Shortlisting.
So,
Shortlisting of candidates. 13/16
मतलब 13/26 Annexure 3.
Shortlisting of applicants for appointment as new retailers in public distribution. सरकारी खुचरा विक्रय केंद्र और इंग्लिश कौन हो? नले आपण लिखदेबे सरकारी खुचरा विक्रय केंद्र.
Fair price of
Fair price of.
फेयर ओडिया कोन सरकारी? सरकारी खुचरा विक्रय केंद्र and it is suggested that indicates fair price shops. Stop. The notification dated 13/3/2026 is pursuant to the applications invited by Mandala Unnayana Adhikari, the block development officer. Block development officer.
Application was invited by the sub-collector Jaspur, Annexure 1. The application
was invited by the sub-collector Jaspur by notice dated 8/8/2024 into bracket Annexure 1. He submitted that by the Lord Council for that the mandatory provisions of who act
order number 4 clause 6.
Order number 4 clause 6 of the public distribution system controllers
2016
2016 has not been followed. Oblique violated. Stop. Prayer of the perusal of the prayer indicates that though the petitioner challenges the shortlisting of the persons named in the notification dated 13/3/2026, 19 persons, they have not been made parties.
Out of 19,
the said aspect is left open at this stage. Issue notice along with this order. Requisites for the learned additional standing counsel upon advance copy served appears and waives notice. Extra copy he shall obtain instruction in the matter. 18/5/2026 IA 5907 of 2026, the allotted AC shall obtain instruction. Yes, next.
Achor item 20. 26. 27.
So since you are present, so I have to adjourn it. Yes. Wait. Let's.
May I adjourn? I will take the copy from
Mr. Petitioner, appellant, 27 appellant. Appellant, ଆପଣଙ୍କ ନାଁ Priyadarshana.
Siddharth Priyadarshana.
Mr. S. Priyadarshana for R2, R1, Mr. Prabhu Prasanna Behra, AC. Any idea when notices were issued, or I have to check? None appears for the petitioner, though the matter is called twice over. The allotted counsel for the R1 and R2 are present. The matter shall be listed for orders in the week commencing 11/5/2024. Yes, next. Okay. Serial decree.
Item 32.
The Sumit Kumar Das for the petitioner. Mr. Anshuman Sethi for the project party. One and two. So Dilip Mahapatra, what are
My lord, I'm appealing on
Sorry. Upon madam?
Dharitri Mishra.
Miss Dharitri, Mrs. Dharitri Mishra on behalf of DK Mahapatra for the OP3. Yes. So this is after notice. So Mr. Sethi, you cannot come to the court.
Your Lordship, I just tore my meniscus. So, the doctor has prescribed me to not walk with my legs. I'm using a stretcher to walk, Your Lordship. Lordship, I can try to make it to the court, but
I mean, like in these kind of injuries, don't take chance.
Your Lordship. Your Lordship.
What can do? You can assign it to Mr. Behra or Mr. Mohanty.
Your Lordship.
Hearing matters, I take the responsibility. Today it has been resuffered. We'll take care of it.
Kibbe asile avta.
As my language suggests,
yes. If you will believe me, from the record I will submit.
No, see takara.
Then case it can be disposed of if my lord
Yes.
What happened here, man? My service was approved. Thereafter, for the reason a particular officer, he was a teacher leader, this petitioner. So that secretary have some problem with this person. He kept that order at abeyance. Approval order was in abeyance.
Approved by the governing body?
Not approved by the government itself.
By the government.
Government release granted it. But thereafter, for the reason Annexure 9 and 10, he has kept it abeyance. I came before this honorable court. These two orders were stayed by this honorable court. And after that, and there is some interim order was there, you release the salary what he was getting. So that was also released, and fortunately, it was before my lord, and my lord in the contempt petition directed, and payment was made because of my lord's intelligence only. So thereafter, in the development is this person, he was getting the pen, he has got the benefit. He was given further promotion to the reader, and now 31/3/2026 he has retired. He retired with the benefits.
Recently.
So, जेहेतु से promotion these are the developments. खाली से कैप्टन एवेंट्स ऑर्डर टा वर्चुअली लिटरली सेइंग वाला खाली रेकॉर्ड अछि बट बेनिफिट से सब नहीं कि रिटायर्ड कर गला तो जदी सेटा खाली सेट असाइड कर देले भी ही विल गेट एवरीथिंग ही गॉट एवरीथिंग इंक्लूडिंग प्रमोशन टू द पोस्ट ऑफ रिटायर
Yes, Mr. Behra, you.
एतिक भी इंस्ट्रक्शन नेले मैं
It is that much will close the chapter.
एटा खाली
I mean, it doesn't require any hearing also.
Will take in.
एतिक
Maybe, I mean, to start with, he did not get it, but later on, he has got everything.
प्रमोशन भी सब्सिट्यूट पाएगा
File
रिटायर्ड
this
मुद्दे दे
memo दे दो.
आगे दे साइंस
Mr. Samir Kumar, appearance लिखे ना. So, Anshuman Sethi along with Mr. VP Behra, Professional Behra, Additional Standing Counsel for the state. It is submitted by the Learned Counsel for the petition, the matter. बर्तमान एटा मोर डिटरमिनेशन रे रोस्टर रे अछि ना नहीं
हां बर्तन आपन से कंटेंट तो आपन ऑर्डर बोल से पाई हिज ना बेनी
एटा रिट पिटिशन
रिट आपन कर आपन
हैज मार्क्ड इट टू
ना ना एटा आपन के असाइनमेंट रे बर्तमान किछ प्रॉब्लम
the learned counsel for the petitioner is had at some length it is submitted that the petitioner has already received the granting aid with effect from date of
194
194
I he got the promotion also
he got promotion the
post of reader mail
from
good कल लिखी तुम डेट खोजी दे
from with effect from dash stop in the meanwhile
हां यस दैट इज देयर वन नोटिफिकेशन होची 1 2005 रो से पाई
1 2005 he while continuing in his
sorry हां ठीक
no I mean you after you file it you check it no difficult while continuing it is submitted that while continuing as such the petitioner has retired
1/2/2009
on attaining age of superannuation on 31/3/26
आगे नहीं हां 31/3/26
31/3/26 the learned counsel files memo of date including copy of the retirement notification
notice
retirement notice of the said retirement notice is served on the learned AC as well as the learned counsel for the OP number 3 stop it is submitted that the challenge the writ application through the जो abeyance order था कितने
annex 9 and 10
the order dated 22/4/2019 and the order dated 27/4/2019 stop Annex 9 is in your favor.
That Annex 10 was
Of course, sentence account.
नहीं Annex 9 10 दीटा को होची मो अगेंस्ट से कैप्टन एवेंस कर देल पड़ा
The prayer in the writ petition is to quash
the मो अगेंस्ट
the order dated 22/4/2019. Yes. The order dated 22/4/2019 into bracket annexure 9 is a communication from the government of Odisha, Department of Higher Education, addressed to the Department of the Director of Higher Education. Raising certain queries. That is quote corridor page 29 रे you are therefore requested up to neki Captain Abats the order dated 27/4/2019 is an office order issued by the Director of Higher Education Odisha which states thus pursuant to the government higher education to neki further orders. Stop. It is submitted that as the events have unfolded, the petitioner, the both the entry order केबे है?
So
After the petitioner approves this court, by filing the writ application, by order dated 30/4/2019, interim order was passed directing stay of the above orders dated 22/4/2019 into bracket annexure 9 and consequential order dated 27/4/2019 into bracket annexure 10. Due to subsistence of the interim order, the petitioner has continued in service due to his unblemished career. He has been given promotion. For his entire service period, has received his salary, grantee and other benefits. He submitted that post retirement of the petitioner, the issue of keeping the approval. Keeping the approval.
Annex 8. Original order.
2018 was 7/3/18.
7/3/18. Yes.
Annexure 5.
No, Annexure 8. 8/3/19, sorry. Annexure 8, page 27. Well.
The approval. Keeping in order dated 8/3/19 in continuation of the order dated 18/2/2019 has become academic. But the learned additional standing counsel has adjournment to obtain instruction. This in the 11/5/2024.
My friend, we पढ़िदेले निजे कहबे ताकरो instruction of the fact record.
He will not he will skip out his name. 4/5 आसो देखियो.
Sir, two dates जोटा मु फुल टे कहि देली से ग्रांटीनेट पाइले 17/10/98 रु
ग्रांटीनेट लिखि देतन मार्जिनल
194 लिखा हिचे सेटा
17/10/98
ग्रांटीनेट आउ इंटर हेले 1/2/2009
1/2/2000
1/2/2005 मु बोली थी ना अच्छी annexure भी document अच्छी.
Yes.
Oblige.
Rest of the matters after recess, and whoever any both counsel are present seek any. Mr. Rao, what is your matter? Senior Mr. Rao.
I have not received copy of the counter. I only appeared on behalf of.
I am not a citizen.
Next matter.
Item 33.
Next matter, okay. Here 4, 5, 6 and 8 are not yet sufficient. Mr. Rao, you are appearing on behalf of?
7.
Mr. Mr. Ekenanda.
SP Mohanty.
Mr. SP Mohanty, Mr. SP Mohanty, along with Mr. J.N. Sahoo for the petitioner. So, Prabhu question of Behra for the opposite party is 1, 2, 1, 2, and 3 quarter. Senior is appearing for?
My friend Mr. Sethi.
So, this is it. So, Mr. Consulan Sethi along with Mr. Prabhu question of Behra. Lauded Junior is Snigdharani Patra.
In the meanwhile, she was regularized. She joined in 2019.
Patra, you are only appearing for one opposite party.
Yes, only one now.
Then others are not sufficient, mostly. Just senior counsel, and with
Tarini Prasad Tripathi.
Mr. Tarini Prasad Tripathi for OP number 7. Snigdharani Patra. Stop. So Sahoo कौन करिया 4, 5, 6, 8
Author notice now.
choice नहीं. It is so old now. The learned counsel for the petitioner shall take steps to take a notice afresh to the opposite parties who remain unrepresented, as the matter is of 2019 and 7 years have passed. Stop. Copy of the counterfeit state file question.
State
file.
Yes, Your Lordship.
I will file the rejoinder, my lord.
Copy of the counter affidavit filed by on behalf of the state opposite party served on the learned counsel, instructing counsel Mr. Tripathi, appearing for OP 7. The learned counsel for the petitioner, Mr. Sahoo, submits that he will file rejoinder, obtain instruction and file rejoinder if so advised. The matter shall be listed after vacation or before vacation.
After vacation or
Yes. Upon steps taken नहीं परिवे. The steps लेते ताले.
I will take steps within 3 days.
3 days. The matter shall be listed. Upon steps ना पे कितने बेर रख लिया.
By tomorrow,
the
my
matter shall be
lord.
listed for orders in the week commencing 4-5
My lord.
to enable the learned counsel to take steps. ଯଦି ଆପଣ ଆଗୁଆ step ନେଇ ପାରିବେ ତାହେଲେ mention ଅଛି difficult because the order has to be there.
My
ଆପଣ କାହାକୁ notice କଣ ନଉଛନ୍ତି କଣ to enable the learned counsel for the petitioner to take steps for issuance of notice afresh to the unrepresented opposite parties. Most of the matters after recess.
Prabhu, I keep journal. Keep journal. Date.
Satish Nota give
Petitioner, final application.
You are Mr. Ponda.
HS Ponda.
Mansusekhar Ponda of the petitioner, opposite party blank. The matter is called thrice over, twice before the lunch break and again after resumption of the proceeding after lunch break. Learned counsel for the petitioner is present and heard. Yes.
Yes, sir.
Yes, please. Yes, Mr. Ponda, please.
Yes, sir. My lord, the petitioner filed an application praying for under section NI Act 130 list conduct Larent JMFC Basdev
Grounds?
The opposite party has threatened to kill him.
FIR?
FIR, sir, Purbo Ankara relative to say Mariki.
Threatened to kill the FIR copy.
Sir, Dorukanti se
Sorry, Rohibe. Court कौन आएगा कोर्ट आपनों को कतारे की क्या खबर दबो
sir.
इठिएगा police station.
No, sir.
You must understand, if I pass a order that so and so has threatened, now it's zero FIR. Now you understand the amendment in BNSS. The FIR can be lodged anywhere, and this is now somebody listening in YouTube will lodge a FIR. Court repetition, threaten जो call जो threat call है, court repetition.
से सर जगह से मार
डरिक रहबे
सर आंको रिलेटिव को से 220 किलोमीटर दूर आसी मारी थिले जो एफआईआर टा सर आमे एक्चुअल करछु
आगे सेटा से कोर्ट रे कहबे जे तांको से एफआईआर केबे दिया
एफआईआर टा सर एटा 24/9/2022 रे हितला सी बासदेवपुर कोर्ट रे पेंडिंग अछि सर ए केस टा किंतु ये डरुचन सर केंद्रापड़ा को जदी एफआईआर टा
डर लगी छी डर पाई किछि को प्रोविजन डर पाई सीआरपीसी यूएनएसएस के डर
एज फॉर द इंटरेस्ट ऑफ जस्टिस
अरे कोर्ट सर अछि ना को प्रोविजन रे अछि
नहीं सर
काई से लेट अस मेक द डिस्कशन लीगली nuanced.
Yes sir.
The learned counsel for the petitioner is heard at some length. He submits that the petitioner, who is the complainant,
no sir, complainant no.
Say कौन?
Complainant is the opposite party in lower court.
अरे वर्तमान petitioner high court रे से किए
सर से होचंदी accused.
The petitioner accused.
Yes.
In 1cc case number 1cc रे से कौन opposite party ना कौन?
Yes sir.
He is the opposite party.
Yes sir.
He is the accused opposite party in the 1cc number 156 of 2023 pending before the SDGM Kendrapada on allegations made under section 138 of NI Act. He submitted that the petitioner seeks transfer of the application from Kendrapada to Basudevpur. And that to his life. On being asked, learned counsel for the petitioner further submits that the petitioner is scared to lodge any FIR against such threat to life. On being further asked whether he has intimated the court in season of the matter regarding threat to his life, again the answer is the accused is scared. In considered opinion of this court, being scared would not form the basis of transferring of the application without any further action being taken, further action having been taken by the petitioner who is the accused. Yes, anything else? Sita matter of right no. The petitioner submits that he shall move the appropriate court. He shall move the court in season of the matter for appearing for ଆପଣ ପ୍ରଡକ୍ସନ ଟା ସବୁବେଳେ କଣ ହେଇପାରିବ ଭିସିରେ ସେମିତି ସେଟା କୋଉ ପ୍ରୋଭିଜନ ରେ ଅଛି ଆପଣ ଯେତେବେଳେ ଆପଣଙ୍କ ପାଖକୁ ସେ ଡରିକି ଆସିଲେ ଆପଣ ତାଙ୍କୁ ଡରେଇଲେ ନା ଲିଗାଲ ଆଡଭାଇସ ଦେଲେ
ମୁଁ ତାଙ୍କୁ କହିଲି ଯେ
ଲିଗାଲ ଆଡଭାଇସ ଦେବେ ଆପଣ ଲିଗାଲ ଆଡଭାଇସ ଯେତେବେଳେ ଦେବେ ମୁଁ ଯାହା ପଚାରୁଛି ଏଗୁଡା କହିଲେ ଆପଣଙ୍କର ଓଜନ ବଢିବ ତ ସିଏ ବି ଡରିଗଲେ ଆପଣ ତାଙ୍କୁ ଡରିଗଲେ ବର୍ତ୍ତମାନ ମୁଁ ଡରିଗଲି ମୁଁ ପୁରା ଡରି ଯାଇଛି ବର୍ତ୍ତମାନ କଣ ଅର୍ଡର ପାସ୍ କରିବି ଆରମ୍ଭ ତ କରିଦେଲି ବର୍ତ୍ତମାନ ମୁଁ ନାଇଦର ହିୟର ନର ଦେୟାର ବର୍ତ୍ତମାନ ସିଚୁଏସନ BNSS 2023 ରେ BNS ଯୋଉଟା FIR BNSS FIR can be lodged anywhere
15/4 ସାର ଅଛି ସେଇଟା
ହେଇପାରିବନି ପ୍ରୋଭିଜନ ଟା କହିବେ ନା ମୁଁ ଆପଣଙ୍କୁ ଲାଇକ୍ କରେ ସେ ମୁଁ କଣ କରିଦେବି ସେମିତି ହବନି ଆପଣ CRPC ରେ ପ୍ରୋଭିଜନ ଥିବ ଯିଏ ଯେତେବେଳେ ଚାହିଁବ ବିଷୟ କରିବ ଫିଜିକାଲ ଆଫେୟାର କରିବ କିଛି ନାହିଁ. The petitioner shall move application for appearing before the court in the trial, court in session of the trial, by utilizing the ICT facility, such as appearing through VC, etc. If any such application is made before the learned court in accordance with law, the same shall be considered by the court, by the same court, and appropriate order shall be passed in accordance with law. Disposed of. The petition is disposed of.
item 9.
चेक आपण इश्यू करथिले आपण चेक टा बाउंस हिट
सी सर फॉर्जरी कर से नहीं चिंगुड़ी ऊपर
कंगनार कले
अगेन
सीबीओटी सेक्शन तो कहि परिबेनी दैट क्रिमिनल ब्रीच ऑफ ट्रस्ट जहा जा लागिवो कोन करंतु सी भी डरिवे तापर एटी डर डरे कोन केस किछि बढिबो वकील किछि एंगेज हेबे यू विल एंगेज मिस्टर महांती यस yes please next
item 9 minutes. Even the lordships had taken the prima facie view.
Mr. You are Mr. Barik or Mr. Das?
Das.
Mr. Pratik Das, item 9. The matter being passed over twice is taken up after resumption of the proceeding of the court post lunch. The listener is present and heard. Yes, Mr. Das.
But it's here in your lordships, in the last occasion, I had submitted to the lordship that the revision petition, in the instant revision petition, I could not annex the execution case, the original execution case, which was filed by the respondent wife. Well, I have received the certified copies of those petitions.
It's not required.
Well,
you kindly go to the order dated 4/2026.
Yes. Yes.
Referring portion at page 26.
Yes. Considering the facts and circumstances.
No.
This one. Referring to the order portion at page 26 of the petition annexed to the writ petition, the submitted the direction for attachment of salary has been passed.
That is your grievance.
Well,
Yes.
your
The relevant portion of the order. Yes, then kindly read the order.
Considering the facts and circumstances, it deems proper to direct the DDO cum CRPF
So also Caliveru,
for the attachment of salary of opposite party for realization of area interim maintenance to the tune of rupees 4,13,000 for the period from June 2019 to September 2023.
Then 3.
Pardon me.
Then paragraph, kindly read paragraph.
There is no direction for freezing of the salary account for realization of entire area maintenance amount of rupees 4,13,000 due from 7/12/2016. The learned court has directed rupees 5,000 per month to be deducted for 52 months. An amount of rupees 15,000 is to be paid as the regular maintenance per month. Prima facie reading of the order passed by the learned trial court does not disclose any impediment for the petitioner to have his share of salary after deduction of rupees 15,000 towards current maintenance rupees 5,000 for area.
Yes.
Then once learner council of petition 6 and has adjournment as prayed for list in the.
Yes.
So
there was no direction to file any execution copy of the execution.
No,
because now
this
that your perception, like threat perception, the salary is threatened not to be drawn. So you have to show that you are facing difficulty to draw beyond 20,000.
Well, it's the what the order says is, and that also fell from the lordship.
The order saying and the authority retaining your, at least you have to file that affidavit. They will be asked. You must understand. You are working in CRPF.
No.
They have an authority.
No.
Maybe even let us assume is that CRPF DG can it not be asked by the court that when the court has directed this court, that when the court has directed to 20,000, why you are keeping the entire amount? We explain. Though it was not that elaborate on that you should have understood why the court has observed this. Because if you are having any difficulty beyond 20,000, then who is not giving the money or retaining the money? Because it is your salary. They have to, they have to tell this court. And that will facilitate your, if at all. I do not know because you are not alleging that. I mean, the court doesn't know. You are not alleging that beyond 20,000 you have any difficulty for, getting any salary.
What I had submitted with your lordships on the last occasion was one is that on the face of the order, there is a word attachment which is mentioned.
It has to be.
And your lordships had taken the view that this attachment would either amount to freezing of it, whether it would amount to freezing of the account.
No, unless
not.
the salary is attached by the court to the, because if it is deposit, it is to the credit of the case. If it is not attached, and then how this court, whichever court, when the executing court has authority without attaching the salary, the account, then the bank comes into play. Because bank is not supposed to even disclose information, much less deduct 20,000 and pay somebody. That is by the direction of the court to attach the account and give 20,000. 15,000 current, 5,000 area. So the language is correct.
Well, my humble submission, lordships, is this. Now, when the initial execution petition was filed, the first execution petition, I had averred before in my objection, and I had also categorically stated that's what I have taken the certified copy, and I could not produce before.
No, that is precise the issue.
Well, I'm just pleased. Lordship,
this is not a public speech on attachment of salary. Let us confine to the issue involved.
Well, I'm trying to understand lordships on that.
You are concerned by attachment of your salary. Your salary has been salary account, not attachment of the salary. It is account, the bank account. There will be a conceptual difference between attachment of the entire salary and the account.
That's what I submitted.
So basically, the issue is that when you are spending time now, what do you want from this court?
I submit before your lordship is this, that I was paying regularly as per the order which was passed earlier. Now that order clearly stated that you have given 52 installments, and that was on the consent of both the parties. Now, even if when the amount was due, the first installment, even if when it was due, prior to that.
You have not read the order. You have to read to understand. 4-2. After 2 months, it is a replay actually. 4-2 order.
Just allow me to.
Nothing. There is nothing. There is nothing in your petition. There is nothing in your case. When did the plaintiff or it is somebody else's brief?
He met me.
Oh, you have to ask him this question now. What was asked, discussed in court on 4th of February. And obviously there is nothing, so that is how he is not responding to you. 4th February order.
I tried to contact him. He's in duty,
so let him be in duty.
Lordship,
So
give
what
me
is
one
the problem? Till today, again saying the same thing, like a mantra that they are consented. There was a direction before the first installment was paid. Execution has been filed. Then I'm asking you, what is the prohibition in the law that the decree holder cannot file execution? Then you are saying so many things. You have to have a legal solution for all. I have been repeating this now. This is my latest coinage. ଆପଣ ତ ଜଣକୁ ଆସି ଜଣେ ଆପଣଙ୍କୁ ତାଙ୍କର ଦୁଃଖ କଥା କହିଲେ, ଆପଣ ସେଟା ଆସି କୋର୍ଟରେ କହିବେନି. That is not your job. Then what is the difference between the person and the lawyer? The lawyer will give a legal interpretation of his problem. That is the long and short of profession. So if there is any difficulty, so that is how the order was. It was suggested that if you have any difficulty, then come back.
Should give me one.
Counsel for the petitioner is again heard at length, as he was on 4/2/2026. She was requested to go through the order dated 4/2/2026, particularly paragraphs 2 and 3. 2, 3, and 4. Apart from reiterating what was noted in the said order, it does not have any further instructions and seeks adjournment. Accordingly, the matter is adjourned to be taken up taken up for fresh admission in the week commencing 27
First of May.
When
First of May.
now the order is complete. 4-5
First week of May. What?
Week commencing 4. When people come with bloated ego, that court has passed an order. You being officer of the court, you have to tell. Court will pass. Court is meant for that. It is not your job that you will still pump up their ego. ତାଙ୍କର salary attachment ହବନି ତ ପଇସା କେମିତି collection ହବ 4,13,000 ଦେଲେନି that was not a ଆପଣ ଦେଇ ଚାଲିଥିଲେ କଣ କହିବା has he done any charity ଆପଣ ଦଉଥିଲେ ଭୁଲରେ 4,13,000 ଟଙ୍କା ଏରିଆ ହେଇଗଲା ଭୁଲରେ କୋର୍ଟ କ୍ୟାଲକୁଲେଟ କଲେ
ନାଇଁ sir ସେଇଟା ମୁଁ ବିଲକୁଲ
then sir why you are just wasting your valuable time you concentrate on some better case 4,13,000 टका 5,000 इंस्टॉलमेंट करछन्ती फिर I have not asked that what is your salary
half of the payment mu already kori sir
what half kale ki full kale is it been discussed
that is discussed in
what
this order.
now are we discussing we are saying that by freezing your account the court is collecting that much of amount if you have any difficulty by getting money beyond 20,000 then you come to court then you are moving around
I'll take that.
ଆପଣ କେତେ ଦିନ ନେବେ 2 ମାସ ହେଲା ତ କରୁଛନ୍ତି
सीताକୁ ମୁଁ
4 ହେଇକି ବର୍ତ୍ତମାନ ମେ କୁ ଗଲାଣି ଫେର
ଆସି ପରମାନେନ୍ସି ଡ୍ୟୁ
ଡିଫିକଲ୍ଟ ପ୍ରଶ୍ନ ପଚାରିଲେ କି ଆସନ୍ତିନି ଆପଣ ଦେଖିଥିବେ ସ୍କୁଲରେ ଯୋଉଟା ପରୀକ୍ଷା ଥିଲେ ବହୁତ ପିଲା ଆଭଏଡ୍ କରିଦିଅ ଇଏ ସେଇଭଳିଆ ସିଚୁଏସନ ସୋ ସେଇଥିରେ ହେଲେ ଆପଣ କଣ କରିପାରିବେ ତାଙ୍କ ପାଇଁ କିଛି କରିପାରିବେନି ଆପଣଙ୍କ difficulty ଯଦି court consider କରିନଥାଏ still possibly suppose when what you have ventilated before this court argued before this court that point was noted also even not if 20,000 beyond any difficulty or there is any problem then you come court and tell that that's it yes next please
which if your lordship should permit me after taking instructions if I may file the affidavit to extent of what is the difference.
Why should I put? ଆପଣ modify ଆପଣ interference ଚାହୁଛନ୍ତି the executing court ର order ଆପଣ CRPF କୋड executing court supreme court CRPF ରେ constable କୋड supreme court you must understand that is what I told you that being a lawyer you must tell that law will prevail there is no you see the court has taken any personal decision the court has implemented it, so the executive court cannot go behind it. And court has been very lenient. Court threatened since you have not executed the distress warrant and coercive detention. Yes, next please.
Achor item 12.
None appears for the petitioner, though the matter is called ice over. Once when it reached, thereafter, about an hour, once when it reached, about an hour thereafter, again, post lunch upon resumption of the days of the court proceeding. The matter was heard at length on 26/2/2026. And the discussions on the legal aspects were Thereafter, on 16/3/2026, the matter was adjourned by the learned counsel for the petitioner. To grant further opportunity, the matter shall be listed in the week commencing 4/5/2026. Copy of this order, along with the next date, shall be intimated to the learned counsel for the petitioner by the registrar. Yes, next, please.
As for item 20.
Lord, it is from Dilip Kumar Sahu for the petitioner. The certificate copy nahi kon hoba?
My lord, petitioner want to withdraw this petition because the revision
because of
against
what?
this case is pending before the district court, my lord. And that is filed by the petition.
Memo, kindly write a memo. Jaha kohachoti.
My lord.
Kagaz sir, diyantu. Mr. Dilip Kumar Sahu for the petitioner. The matter was passed over twice. Again, it is called after resumption of the proceeding post lunch. Resumption of the court post lunch. The petitioner, the petition is in the revision application. The petition in the revision application is the husband in the marriage.
15.
He has challenged the proceeding in execution case number CMC number 09 of 2013, CMC number 80 of 2017, and CMC number 219 of 2019. The matter was presented on 3/3/2020. 3/3/2020. Removal of defects on 21/11/2025. Thereafter, before the bench was adjourned for removal of defects within 2 weeks. As directed by order dated 10/3/2026. Stop. The learned counsel for the petitioner seeks files memo of date, which states thus: in view of the above, the petition is disposed of. Copy of this order shall be forwarded to the learned judge, JMFC Binika, to be kept in the records of CMC number. Yes. Yes, next.
As for item 26.
The none appears for the petitioner, none. Opposite party blank. None appears for the petitioner when the matter is called. The matter was had at length on 24/2/2026. The deliberations on law were noted in the said order. One. the matters to grant further opportunity. The matters will be listed in the week commencing 27/4/2026. Copy of this order, along with the next date of listing, shall be intimated to the learned counsel for the petitioner. Yes.
Before.
Yes,
My lord, I am appearing for the petitioner.
Yes.
I'm for the petitioner in this case.
Yes.
I filed this revision against the order passed by Judge Family Court Hon'Ble. Sir, the marriage between the parties solemnized in December 2016.
Sir, if it would be better if you appear physically, because there will be some communication gap if you go for final hearing in revision application.
Sir, very small matter, sir. Only one point I shall raise.
So,
only one point, sir. Sir,
what you argue, first of all, you must know you are arguing a revision. There is a scope of revision.
Sir.
So you tell the best point.
Sir, I shall tell only one point, sir. Sir, it is Lordship Perry that it is a pleading of the wife petitioner that she was serving as a teacher.
You are the husband who was the opposite party.
Sir.
So you start with your written statement.
Sir. Sir,
anyway, this is the problem. When you appear in VC, there will be some dislocation.
Sir, there will be no problem. Only one point I shall raise, that it is the pleading of the wife petitioner in the lower court that she was serving in a private school. And it has been reflected in the judgment of the Annexure 1, page number 2 and line number 16. They forced the petitioner to leave her teachership job in Bhuvanpur school. Where is the annexure affidavit in the as per the order of the apex court, Rajesh versus Neha, the filed by the wife in the court below, wherein at para F, details of the income of the deponent, she disclosed nil.
Sir, where you have stated in your written statement?
I have stated that she was working in a private school and
I hope I have to tell you in Odia. What you are stating now, where you made this statement before the trial.
So, sir, I have raised it in the trial court, but honorable trial court told that
you show your plea that where you raised this point before the trial court, what you are arguing now.
Sir, I have made my submission in my written statement, and the honorable court reflected it in
written statement. Dekhantu, sir. Paragraph, page, dekhantu. Don't make a speech.
Sir. Then I may be allowed to.
Yeah, I'm confident I am making a speech, but I am not making a speech. I am simply asking you go by the pleadings. What was your? Then in the next point, what was your how you have cross-examined the petitioner? Whether you have asked this question?
Sir. Allow some time, then I shall file the written statement.
Time allow kona
No, sir. Upload kar debi.
That way, it is open for you to argue in revision. Let us assume that then what turns on that?
Sir, if she has got income.
Turns on that.
Sir, if she has got income, if she is serving in a private school, then the trial court hold me as a daily laborer. And my income was assessed as 333 rupees per day and 8,000.
Rajnish versus Neha pura padu na.
Sir.
Rajnish versus Neha has devoted 6 paragraphs that when the wife income, wife earns money, what would be the compensation? Monthly maintenance. What is the awarded amount to the wife?
3,000 rupees, sir.
3,000. You must. In today's world, why the wife has been awarded 3,000? You have to read. Then if you read, there is no case. There is no case.
When I was
No adjustment. No adjustment. I can't waste time like this. There
sir,
is nothing.
she is working and she is earning money 5,000 rupees per month. That is my point.
Have you collected before making your speech? Have you gone through the Rajneesh versus Neha? Have you do you have the judgment?
Sir, I have gone through that judgment, but if somebody is suppressed.
Hey, instead of making a speech on the judgment, try to read the judgment. Start reading.
If somebody suppress our income, then it constitutes a criminal offense. Then instead of doing that,
suppression where you have stated in your written statement, or where you have asked in the cross-examination that you have suppressed your income.
I have made in my written statement regarding her income. I have disclosed in my affidavit also that she is doing.
I have disclosed. Suppression question I have disclosed. Where you have asked this question to the person who was suppressed.
Sir. Running page 17, internal page 11. This query is answered by the trial.
Sorry?
Internal page 11, running page 17, the brief. The trial court has answered that query.
Trial court chhadu to jaini. Sir batan struggle kurchunti sir chunti bartaman pleading pocharla.
That is the answer.
Sir pleading ra chanti.
Till date a single pie has not been paid. They have kodieru aji 15 ଅଛି. ନିହାଟନ ଦିଆ କୁହାଯାଇଛି ସେଟା ପେ କରିବି
3,000 rupees cost ପଡିଥିଲା ଦେଇଛି ତାପରେ ଦେଇନି କାଇଁ ନା ଆମେ ଡେଲି ଲେବର and
you are arguing a case without anything. The case is as bad as a bad could be.
Sir, the judgment itself speaks everything, sir.
अरे आपण तो पढिबेनी आपण सेतळु रजनीश वर्सेस न्याय खोजुचंती
नहीं सर रजनीश वर्सेस न्याय खोजनी मु कोठी पचारी जी सेटा खोजी मु आई हैव पुट दैट क्वेश्चन टू द पिटिशन ए वाइफ
कोन कहले
से
तका आंसर कोन कोतु पढो कोइ पचारचंत तापर देखिबा लेट अस आसिम आपण जा कोजु ठीक को
को भीतर डाइवोर्स हे जाई मेंटेनेंस कथा तापर
फिर let us not shift the goalpost. Rajneesh versus न्याय धरचंती
नहीं सर judgment right now is not available. I'm finding
किछि नाही no merit.
Sir, correspondence with the OP para 3 it has been put to her. I have also filed a counter so called the OP admitting regarding the partial degree of divorce report. I have also filed a
पढुचंती आगे क्वेश्चन टा आगे पढिबे उत्तरटा तापरे पढिबे कोन पचाले पढंतु वो तो सब जहाँ पचाले आपण सार पूछो
That's fine. Not there in our evidence.
So,
But as per her pleading, she is a school teacher and she has not disclosed.
Sir, case conduct kariba. I mean, I'm rather. I'm saying that I'm a naive in doing trials. Stalwarts are there, but these basic fundamentals have to be noted that you can't re-argue. You're not there, not there. Leave it there.
My simple prayer, let it be remanded to the lower court again to assess the income of the wife and then pass.
When you are arguing in High Court, sir, when you have started arguing in High Court, you have to take note of all the judgments on this aspect. How the Supreme Court is again and again insisting that these maintenance cases should not be kept pending. The leading decisions regarding execution has already directed by Supreme Court last bench that execution cannot be kept pending. We are holding meeting in the administrative side as supervisory judges, including your district, that why these matters are kept pending. You read Rajneesh versus Neha, that case the Supreme Court has expressed for 7 years litigation continues. The person claiming relief could not get the relief. How it can be remanded?
When she is pleading that I am serving in a private school, and
you must understand what you are arguing. You are arguing against yourself. Unwittingly, you should not have asked this question to her, because the law is very clear. The wife may be a millionaire, but if she lives like a billionaire with her husband, she will continue to live like a billionaire. The husband cannot lament because the wife is a millionaire. She is not entitled. And you see the amount. She has been awarded 3,000.
She is teacher.
You must understand.
Her declaration.
That is how I was asking you that. Anyway, you have not asked that question. You leave it. You are fair enough. The learned counsel for the petitioner was heard at length. He addresses arguments being present at the virtual court, High Court of Orissa, Hon'Ble. Mr. Pradeep Kumar Nath Likhiwe for the petitioner, Mr. Rajesh Kumar Mahapatra for the opposite party. The petitioner husband is before this court. After respirator लिखने, the counsel has been present. After the petitioner husband is before this court. Challenging or seeking revision of the order dated 29/8/2023, passed by the Lord Judge Family Court, Hon'Ble. CR.P. Case number 29/2020. The application was filed. The said application was filed under Section 125 of CRPC. And substituted by perimeter provision contained in Section 144 of the BNSS 2023, bracket closed, by the wife in the marriage, giving rupees 15,000 per month towards her monthly maintenance. Before the learned trial court, of the parties, the marriage was not disputed. It was celebrated on 2/12/2016. The present petition appeared before the learned trial court, learned Judge Family Court. he filed his SOCUS stating himself to be a daily laborer, depending on his father and staying in his village due to scarcity of work. The Lorded Trial Court, the Lorded Judge Family Court, apart from the pleadings of the parties, that is the plaint and the written statement, it relied on the evidence of the three witnesses on behalf of the petitioner, PW1 being the petitioner herself, the court has referred to the, as further relied upon the evidence of the opposite party, who examined himself as OPW1 and another individual as OPW2. Two documents were marked as exhibits by the petitioner wife, and one document was marked as exhibit on behalf of the appellant, who is the petitioner here. Seeking revision of the judgment, it is contended by the learned counsel for the petitioner that the affidavit filed for the Learned Trial Court in terms of the directions contained in the decision Rajneesh versus Neha, and paragraph 7 indicates so and so. Paragraph 7 लिखी देंगे. The petitioner wife before the Learned Judge Family Court, though worked in a school as alleged by the opposite party, she did not indicate the same in the affidavit in terms of Rajneesh versus Neha. In response to the said submission, the Learned Counsel was asked to show before this court, while considering the revision, whether such a pleading was made in the written statement filed by the opposite party, and whether any question was put to the petitioner wife in cross-examination, making the allegation, and if such question was put, then what was the answer of the claimant wife? The Learned Counsel for the petitioner took some time to go through the records available with him, and he fairly submits that no such question was put, nor it was pleaded in the written statement, making such raising such contention. Cross-examination is relevant in the present case, as the opposite party raises a issue, raises a question regarding authenticity of statement made in the affidavit, paragraph 7. Mr. Nath, paragraph 7 पहले ना?
Yes, paragraph affidavit, paragraph F. Income of the
F for father.
F টা income of the deponent. Income of the deponent.
Fine. The learned counsel for the petition is also asked, was also asked if it is assumed that the assertion made by opposite party is correct, what would turn on the same? In Rajnish versus Neha, Supra, Supra, the apex court have dealt with the situation where quote into bracket C, where wife is earning some income, quote ends. The relevant paragraphs from the said judgment of the Honorable Supreme Court is reproduced herein. The CC online print achieve. Sheet as if 90, 90.1, 90.2, 90.3, 90.4, 90.5. So, are you pleading, Mr. Nath? Anyway, any other submission? Any other submission?
Efforts have been made by the petitioner to bring back his wife, but the wife was related to him. So it is efforts have been made by the husband to bring his wife, but the wife respondent of this case intentionally.
That is more factual.
My part of
that you have to prove in your pleadings, and you have to efforts of the husband to bring is a plea always in defense in 125 applications. So how you have proved that?
I have had some documents.
You must understand it is a matter of pleading and evidence. It is not a matter of speech.
When I filed the divorce case, she didn't like to appear there, did not like to contest there.
No, 125 is a provision da achi. You are not arguing 25 or 24 petition. 125 former wife.
Already quoted.
Yes, the learned counsel for the petitioner refers to the fact that the petitioner and the opposite party in the present application, who were the applicant and respondent before the learned judge family court, have divorced, and claim for maintenance under section 125 CRPC is not maintainable. It
was an expected decree of divorce.
Whatever.
That is.
The provision contained in section 125 CRPC is very clear to the extent.
Explanation B.
Explanation B
of 128, section 128.
Yes.
The subsection which is 125, 3, 4, 5.
Explanation B appended to 1.
Explanation B. The body also soon better.
It is quoted. Page 8 only. In judgment, page 8 only. Page 8. The explanation.
Yes, anything else, Mr. Nath?
No.
Mr. Mahapatra. Yes.
So, but
in response, the learned counsel, Mr. Mahapatra, for the opposite party, refers to the judgment of the learned judge family court. Paragraph
page running page 8, para 7.
Running page 8, paragraph 7.
Continuous.
It is reproduced herein.
Yes. And the other portion, page
125, the CRPC, the
CTH, page 8 judge.
Achha.
Say plead of certain content.
Yes, I also agree that a divorced wife also can get maintenance.
Correct, correct.
It is there in the 125 CRPC. Explanation being appended to section 125 CRPC provided that the wife includes a woman who has been divorced or has been obtained from her husband and has not remarried. Then she
Right. You're correct. बाकी से जो आपनकर इनकम कथाटा से पारा 7 आपण सेटा रिलेट
पारा 7 रा एई डील कराइछि बट इनकम पॉइंट रे तांकर क्वेश्चन रो आंसर कराइछि पेज 10 रे लर्स रनिंग पेज इंटरनल पेज 10 कंटीन्यूअस पारा 8 रे कंटीन्यूअस रे एट पेज 10 आपण पाइबे मु पढि दोछि पारा पेज 10 रो रेलेवेंस टा पढि दोछि इंटरनल पेज
copy of the FIR.
Yes, start only. The relevant portion, the OP stated that the petitioner is earning money out of tuition. He has no document to that effect. Full stop. To whom the petitioner is teaching is stated. Full stop. Therefore, the
actually, what Mr. Nath was arguing is something else.
Regarding service, that also minus. Para 7, page 7, 11 also that is also been dealt. Mu astan city koithandi.
Sorry. Para.
Running page 11.
Para internal page 10.
Running page 17.
The copy of the FIR to neki for sufficient reasons also.
Page 17 रा internal page 11 first. Page 11 रे भी से जिनसे डील करा है.
Running page 17 internal page 11.
That's it.
Nothing substantial has been brought out from the mouth of the PWC.
The disbelieved evidence. UPW stated.
So this specifically, I was asking Mr. Nath that what was there.
Yes, ma'am.
Up to maintain herself.
My submission is that she is capable of maintaining herself. Since she was serving, it is as per her pleading, she was serving in a private school.
So again, when daily wage has reached 800, around 3,000 tanga seti pain del. Not say 30,000 with the you must understand that. The language used by the Honorable Justice Deepak Mishra is that it is not a fortune conferred on the wife. Language uses that the High Court shows non-application of mind on part of High Court. Yes, noted that that paragraph is noted.
Lordship.
Yes.
There only it is been dealt.
Yes.
By the Land Trial Court. So it says that OP2 stated in his evidence that the person is serving as a teacher in a private school and getting monthly salary of 5,000. They said evidence of OP2 is not corroborated by the OP. No reliable evidence adduced to show that at present the OP is serving as a private teacher. In which the teacher now is not disclosed by OP2. And it is also the case that the peasant wife, the appeal party, was forced to leave the job. That is also the contention of the wife before the Land Trial Court. That is in her. That is.
It has been noted.
Yes, Lord. Grateful.
When she lodged FIR, when she filed a 125 petition, everywhere she disclosed, beside all other allegations, she was forced to leave her teachership job. It was her pleading.
So, I mean, in the trial, you look at internal 11, page 17 of the judgment, of the brief, 17 of the brief. Mr. Nath, could you find that internal page 11, page 17?
Internal.
Running page 17, internal page 11.
Judgment copy रे sir 11 number page टा.
That's
Nothing substantial has been brought out from the mouth of the PWs to disbelieve their evidence. Then OPW2 stated in his evidence that the petitioner is serving as a teacher in a private school and getting monthly salary of 5,000. The said evidence of the OPW2 is not corroborated by OP.
Sir, my submission is that when a person claiming,
Sir, you have not supported your own witness.
sir, when she is pleading that I am serving as a teacher.
Now it is too late, sir. Too late in the day for this court again to. In fact, what I was thinking is that your evidence is much worse than that. You are OPW1. OPW2 said that you have not supported, or maybe you missed it. That's another thing.
Yes, yes.
And this is a matter of positive evidence. You have to simply say that she is working in such and such place, and it says the court has found out. No reliable evidence for the said evidence of OPW2 is not corroborated by OP. No reliable evidence adduced to show that at the present OP is serving as a private teacher. In which school OP is serving now is not disclosed by OPW2. This is the problem, sir. This is the problem. Anyway, you have done your best. Thanks for your time. The revision application is dismissed being devoid of any merit. Copy of this short. Any I will add the other discussion business versus there and also Samima Faruqi. Let me dictate also. The scope of revision, interference in exercising power of revision by this court in the kind of order that is being dealt with, that is grant of maintenance under section 125 CRPC, has been authoritatively dealt with by the Honorable Supreme Court in Samima Faruqi versus so and so, paragraph 19 and 20. Yes. So now that is a judgment by Honorable Justice Deepak Misra, as his lordship then was. And he has very crisply dealt with, and coincidentally it is in 125 CRPC. Yes. Next.
Get fluids.
May I please, Your Lordship?
Yes.
Lordship, I am for the petitioner husband. Lordship, I am praying for an amendment.
You are Mr. Samal?
Yes, Your Lordship.
Mr. P.P. Samal for the. Mr. Chand is fine. He's not coming.
Yes, he is fine. He went to Bhubaneswar for some work.
Mr. P.P. Samal for the. I mean, that is in the interest of profession. That shows that he's fine. So B.P. Samal for the petitioner, Mr. Rabi R.M. Behra for the opposite party. The London Council for the petitioner seeks and has adjournment. The matter shall be listed for the. The matter is listed for hearing under the heading for admission. केबे आसीबो मिस्टर बेहरा कोन आपण कोन सीधा आर्गुमेंट कोचन डेट आपण कोन
ये लॉर्डशिप में फिक्स इट 4th
4-5 तो वी कमेंसिंग 4-5 2026 yes
36
Lordships, item 36, I am appearing on behalf of the OP husband.
Yes.
An application for vacation of stay, my lord, has been filed. And if the objection is otherwise ready, may I pray be taken up any other day? Because, my lords, here it's an ex parte judgment. I have filed an application under 913, which is slated for evidence on 20th of this month. And the evidence affidavit is otherwise ready, my lord. So,
the revision is again amount of.
Yes, my lord.
Maintenance amount. Maintenance amount challenge culture.
My lord, the wife has come.
Enhancement.
You are seeking enhancement.
Yes, sir.
So Pulakes Mohanty for the petitioner, Ms. Patricia Naidu for the opposite party. Learned counsel for the opposite party being present in VC addresses arguments. She sits for the time to record the objection to the IE. IE टा फाइल कले आपण
नहीं आईएससी फाइल कले स्टे हला तापरे बे वैकेशन तापरे आउ दीटा डेट रे से एविडेंस
to obtain further instructions in the IA. The matter shall be listed in the week commencing 11/5.
My lords.
37. Mr. Biswajit Prasad for the petitioner, Mr. Saurav Tibrewal for the opposite party.
My lord, in this last occasions, my lords, I pray that matter should be posted to the mediation center of the High Court, my lord. The Nonen brothers, my lord, take instruction regarding
the difficulties that the wife has been, she was beaten very badly in this case, lordship, and the allegations of extramarital affair. She has called husband red-handedly, so she is not in a position to go for mediation, lordship. I have taken the instruction.
The application, Mr. Prasad, the original application which is being sought to be transferred.
My lord.
That is on the which provision?
My lord, in the criminal procedure, my lord, the file, my lord, 1447 of BNSS, my lord.
Correct, sir.
My lord.
For transfer 144.
Well, grounds, my lord.
144 seeking maintenance.
My lord.
What mediation can be done?
My lord, subsequently, my lord, the
because Mr. Prasad will not pay, Mr. Tibrewal will not pay.
No, my lord. My lord.
And George is out of question.
My lord. My lord, correct. My lord, so
then what mediation will happen?
My lord. That lord, the peasant petitioner filed the section 9 of the Hindu.
You see, you must understand.
My
so, this question has some relevance. Sir, there is a family court rules. It provides for family court counselor. Appointment is made. There is no such perimeter provision in High Court. So, in those matters, there is a possibility if you move the trial court for conciliation, something may happen. But High Court mediation, what the mediator will do when somebody is seeking 144 maintenance?
My lord, I'm
under 125.
My lord, I am submitting, my lord. The my lord daughter, my lord, is proceeding study at Bhubaneswar in Vidyalaya, my lord. So far, my lord, the welfare of the child, my lord, the peasant petitioner, my lord, paying the house school fees, my lord. So far, my lord,
school fees delay. Maintenance lagu podibo in 144 re kichi provide.
No, my lord, I am not saying.
You should not spend time at 4 almost is going to.
My lord, both another aspect.
Make a submission.
My lord.
There is a case law that if the husband pays for the school fees of the child, it's not to maintain the wife.
No, my lord, I am not only
after you complete your submissions, I will ask you this question.
My lord,
how is it relevant in determining the lease?
My lord, the wife also filed a transfer petition before the also tag with this application, my lord. My lord, in this case, my lord, notice
Mr. Prasad, if both of you agree, a place will be fixed. That's a different thing.
My lord.
But we are now discussing that when you are saying that there should be mediation, what sort of a mediation can happen in case of a maintenance?
No, my lord.
Because maintenance is regarding somebody's subsistence.
My lord.
To prevent destitution and vagrancy.
My lord.
Maintain ଆପଣଙ୍କର mediation ରେ destitution and vagrancy କେମିତି ହେଇପାରିବ? Law elaborated way back by the Honorable Justice Krishna. So when somebody is seeking maintenance, it is the basic bare minimum survival. Mediation कौन होगा? अपन mediation कोथरे होगा? Permanent alimony.
My lord. My lord, sir, query is correct. My lord,
so far as correct, no sir. I have to pass a order. अपन जो क्वेश्चन से maintenance से mediation करिवे, कौन mediation नहीं
पाए? नहीं, peasant petitioner
अपन basic bare minimum पैसा देबे, से ठीक तो करना है कौन?
नहीं सर, मैं ताऊ नब्बा पे ही चाहूँची।
अपन के नेबे चाहिए इंटरेस्टेड, सेट्रे कौन अच्छी ताको अपन पैसा देले कौन से जीवे नहीं?
सर, मु
कौन जो दी से?
चाहिए कि
husband रो defense ना जे मु नब्बा पे चाहूँची पैसा देबे नहीं. Is there any case law on that? provision the 125 रे नहीं.
provision
Sir, it has gone to that extent. 125 has been interpreted. Earlier decision also. Any kind of stay together, the person is entitled for payment of maintenance.
My lord,
ସେଥିରେ ଆପଣ ଯୋଉ ନବା ପାଇଁ ଚାହୁଛନ୍ତି କଣ କହିବେ
my
ସେତେବେଳେ?
submission is that my lord, the opposite party wife also staying at Bhubaneswar. My lord, he is giving false affidavits, my lord.
ଭୁବନେଶ୍ୱରରେ ରହିଲେ 125 maintainable ନୁହଁ ନା କଣ?
No, my lord. I'm a my lord. Both the cases, the case is trial put at Bhubaneswar for
We
expedient.
have gone back, change the topic. Sir, we are discussing mediation. So what mediation court will direct when she is seeking maintenance?
Yes, sir. Mediation accept acceptance by only
That's what I said. That both of you agree for a place, the court will direct.
Sir, ମୁଁ last occasion ତ ନେଇଥିଲି instruction ସେ ମନା କରୁଛନ୍ତି.
ତା ସାଙ୍ଗରେ mediation ର କଣ ସମ୍ପର୍କ ଅଛି?
Mediation ସେଟା ସେ
କେସଟା ଟ୍ରାଏଲ ହବ ଟିଆର 144 BNSS ଟା କୋଉଠି ଟ୍ରାଏଲ ହବ? ସେଥିରେ ଆପଣ କଣ କରିବେ ସେଟା ଅଲଗା କଥା. ବଟ୍ ଆପଣ mediation କଥା କହୁଛନ୍ତି ନା?
Mediation sir only accept
mediation will frustrate the entire thing.
Agent petition is ready to accept the wife and child, minor child.
Again, readiness for acceptance of wife is not exception in 125. Well, I have to reject that.
Petition also
125 chair readiness of husband କୋଉଥିରେ ଅଛି ସେଟା? Explanation ଦିଆ ହେଇଛି?
No, my lord.
Explanation ରେ କହିଲେ ଆଜ୍ଞା ଉଲ୍ଟା just ଆପଣ ଶୁଣିଲେ. Explanation says that a divorced wife can claim maintenance. ଆପଣ ତ କହିପାରିବେନି ନବାକୁ ଚାହୁଁଛି. ଆପଣ କଣ divorce child against କଣ ନବାକୁ ଚାହୁଁଛି କଣ? So in fact you are also mixing it up.
ମୁଁ section 9 file କଲି restitution consulates at Bhubaneswar. Also the present opposite party wife also filed the petition for transfer of the Bhubaneswar to Baragarh.
ଆପଣ କୋଉଠି ଚାହୁଁଛୁ?
Sir, ମୁଁ ଚାହୁଁଛି Baragarh to Bhubaneswar. Though the present
145 ପଢିଲେ
145 maintenance sir ମୁଁ sir the that as per my provision my lord the that is the my child's and wife and
whenever the last 5 years going to 5 years whenever I have been assigned this assignment 125 is the only provision where it provides
maintenance to wife and one child
jurisdiction. 145 देखो
procedure my lord under 144 procedure
only पढ़ो तो 145 ना 144 no
145 lords.
Yes. On the two by पढ़ले मुंह करे कौन जानी भी किंतु
मुगल लॉर्डशिप का slowly पढ़े मुगल my lord sir
muted no
my lord
तरवर ही पढ़
144 procedure proceeding under section 144 may be taken
145 अपन 144 कौन तो बारह में पढ़ चुके
140
yes
144
दितर गले रे अपन को जो 145 अपन again को जो 145 yes procedure yes
may be taken against any person in district
in any district
yes one A where he is or B where he or his wife
so that is B sir
B my lord
so eta apanakar 24 application no
no my lord I'm
so you must understand if you want transfer of 144 application 145 is a statutory mandate
my lord
so I'm yet to pass that order and I have not found any decision also
my lord
because the statute has made it where the wife and child they can read further even it
be as per see where he last resided with his wife or as the case may be with the mother of the illegitimate child or
then can you read that
next where his father or mother resides
so this is a provision which itself provides inbuilt jurisdiction. This is not a section 24 or other general application where criminal trials have to be transferred. The purpose of 145 be specifying because the statute, the legislature intends that the person, illegitimate child, father, mother, whoever seeks the maintenance, destitute lady, divorced wife, where they reside, they will file it. So whether you file section 9, section 13, section 18, how does it matter?
My lord, rejects, my lord, basically.
125 sagare, now you read a section you have filed, that is section 19 of Hindu Marriage Act.
My lord,
That definition, section 19, conferring jurisdiction in Hindu Marriage Act. Achi, bhai achi na devi.
My lord, I pray lordship one posted to another date. My lord,
125 should not be kept pending, sir.
No, my lord, move only short date kouchi mana mama ye date should owners day
Sir, I am yet to keep it, sir, even
more decision ta devi so that the welfare of the child, my lord, the
sir, welfare of the child ray 125 transfer he parivan 145.
as per lordship my lord, section B where the rejects se Bhubaneswar rohuchendi suppressing the material facts lordship se nije file korchendi bi affidavit re
ଶୁଣନ୍ତୁ ଆପଣ again ଆପଣ 4 ଥର 5 ଥର କହିଲେ ଭୁଲ କହିଲେ ବୋଲି ପଢେଇଲି 145 ଆପଣ ଫାଷ୍ଟ ଏଇଟା କଣ ପଢିଲେ
ଏଇଟା କହିଲେ where he is or in any district ରେ କହିଲେ
145 ର ପ୍ରୋସିଜର ଲେଖା ତାପରେ ଲାଇନ ଟା ପଢନ୍ତୁ
proceeding under section 144 may be taken against any person in any district.
Any person, any district. So ସେଇଟା ହଉଛି opening statement. ସେଇଟା qualify ହେଲା B ରେ ପଢନ୍ତୁ.
B ରେ କହିଲା where he or his wife resides.
ଆପଣଙ୍କର ଯଦି ଆପଣ 125 କେସ୍ ରେ ଆପଣ ହଜବେଣ୍ଡ ପାଇଁ ଡିପେଣ୍ଡେଣ୍ଟ ଆପଣ କେସ୍ ରେ ହାରିବାକୁ ନା ଜିତିବାକୁ ଚାହୁଁଛନ୍ତି?
ଆମେ ଜିତିବା
ପାଇଁ ଚାହୁଁଛନ୍ତି। ଯଦି ବି ଆପଣ assuming what you are saying is correct, the Bargad court lacks territorial jurisdiction, assuming. So ସେଇଟା plead କରିବେ ଏଥିରେ ବସି କଣ କରିବେ? Now you kindly look at 19 ଆପଣଙ୍କର ଯୋଉ section 9 ରେ ଆପଣ mix up କରିଦେଲେଣି ତାକୁ
19 last resides or all the things as per the provision also that has been mentioned.
There is a purpose. ଆପଣ kahinki difficulty to suppose now I dictate following you, suppose I accept your argument that in view of section 19 125 is to be tried at Bhubaneswar. Read section
19 court to which petition shall be presented. Every petition under this act shall be presented.
So every petition under this act. Now 125 or now 144 is not a petition under this act. That is a 125 is a petition, 144 now is a petition under VNSS 23. 145 is the guiding section for territorial jurisdiction. So that order is that order will be erroneous. Suppose I accept your contention, apply section 19 to section 144, section 19 of Hindu Marriage Act. Let us assume I will apply. That will be erroneous. If you want 125, ଆପଣ ଯଦି ଚାହୁଁଛନ୍ତି ଜିତିବା ପାଇଁ ଚାହୁଁଛନ୍ତି ଆପଣ ସେଠି ସେ ପ୍ଲିଡ୍ କରିବେ territorial jurisdiction ନାହିଁ କୋର୍ଟ ଯାହା ଡିସାଇଡ୍ କରିବେ. But you see the opening sentence of 145 against any person in any
district.
So that's the legislative mandate.
More Koyakata, my lord, only submission that he has filed this affidavit regarding this aspect. This court is also previously, this honorable court asks whether she is.
Previously, I cannot take into consideration. Section प्रथमे कहले जे section 125 144 रे section 19 of Hindu Marriage Act apply करिवि 145 is very clear that cannot
rejects पर तो जो super the suppression material facts
job suppose she seeks a job joined somewhere in Bombay she will file 125 in Bombay it is maintainable that is what the legislative and it's a very old statute 125 was interpreted by long back by Justice Krishna. That is nuwa apno DV Act bhaliya nuwa ki so
125
I think maybe it is prior to section 24-25 of Hindu Marriage Act also. Only thing I am only just adding that paragraph. If you want to avail ICT facility, then you will make an application. The state application shall be dealt with by the court in accordance with law. ଆପଣ appear କରିବେ ନ କରିବେ VC ରେ appear କରିବେ possibly 125 since it's a matrimonial proceeding court will allow but this court cannot direct because there is no provision that much I will observe and both the sides C may appear in VC you may appear in VC 125 ର order ଗୁଡାକ ଅଛି ସେଟା କରିଦେବେ It is submitted by the learned counsel for the opposite party. Agar lekhon Mr. Biswajit Prasad for the appearance dakhi. Mr. Biswajit Prasad for the petitioner, Mr. Saurabh Tibrewal for the opposite party. The learned counsel for the learned counsel for the petitioner was heard at length. The learned counsel for the opposite party also responded in brief. The petitioner husband in the marriage before this court seeking transfer of the criminal proceeding bearing CMP number 29 of 2025 filed and pending before the learned judge family court Borgad to the court of learned judge family court. The same proceeding, sorry, the same proceeding has been initiated under section 144 of the Bharatiya Nagarika Suraksha Samhita, BNSS 2023, by the wife in the marriage, seeking proceeding copy of the
Sir, Annexure, Lordship, one page.
Annexure one.
Annex one. Proceeding, page 14, Lordship.
Filed under the section 144 of the BNSS 202 2003 भूल लिखा है ना, seeking monthly maintenance from the husband. इधर कोई entry order है कि pending है judge?
She has not got anything as of now.
Due to pendency of the present proceeding, the proceeding before the learned judge family court Borgad has been interdicted as adjournment was allowed by the order of this court. As adjournment to be sought for before the learned judge family court was allowed by this court by order dated 19/6/2025. The territorial jurisdiction in which the application under section 144 CRPC, 144 BNSS 2023 can be filed has been itself provided in the BNSS, that is section 145. The correspondence in the CRPC where section 144, section 125 and section 126 respectively. For convenience of reference, section 145 CRPC is reproduced herein. It is submitted by the learned counsel for the petitioner that the petitioner resides in Bhubaneswar.
Well,
submission.
Petitioner, opposite party also wife.
Sorry,
Wife.
the petitioner before the learned judge, the learned family judge Borgad.
Well, I am
Who
also
is the
giving
opposite party in the present application.
My lord, I am submitting the prosecuting of the daughter minor daughter. My lord.
Sita कौन होगा Sita?
Sita only well, observation maybe.
Sita कितने होगा?
Sita हमें paragraph
comment टा सुन लें कि justice मिश्रा करो.
आई हाँ.
Non application of mind by the High Court. मतलब सेटा करे कौन
आई
हठात 125 रे मु झियो पढ़िया विषय रे आरंभ करती. और मुझसे कौन होगा?
मतलब मुन्नी
किसी किताब को कौन होगा? ठीक. I have to reject it. झियो कोटी minor daughter कोटी पढ़ुची is not a relevant factor for maintaining a 144 application. So far 145 is sufficient.
For residing, so far is residing at the daughter and wife. That's why I am praying.
Resides at Bhubaneswar. In considered opinion of this court, that is a matter of evidence and pleading. Whether that would be an issue before the learned Judge Hon'Ble Court is beyond purview of the present adjudication. In view of the specific provision contained in section 145 of the BNSS, the wife has a choice of filing the application where she resides, and the section itself provides that a proceeding under section 144 can be initiated before any person in any district. So, it is submitted by the learned counsel for the opposite party that the amendments made in the petition as well as the submissions made to support the prayer for transfer of the application is not correct. The wife, opposite party, has been harassed a lot. She has gone through immense difficulties, and she has sought for intervention of the court seeking maintenance. The place of initiation of the proceeding is in accordance with section 145 of the BNSS. Therefore, he prays the application to be dismissed. Having considered the rival contentions and considering the provisions contained in section 145 of BNSS 2023, in considered opinion of this court, the application, the application seeking 144, application under section 144 can be filed at the place where the wife has filed, it is at Borgad. The prayer for transfer of the same on different grounds such as convenience of the husband, study of the minor child are not relevant considerations. Accordingly, the petition has to be rejected. However, it is further directed. However, it is if the parties before the learned Judge Hon'Ble Court are so advised, they can make application before the learned judge, before the learned court for appearing by utilizing the ICT facilities such as virtual hearing from remote location, etc. In case such application is made before the learned court, it shall be considered and appropriate orders shall be passed in accordance with law. Yes.
Item my lord 305, the wife also filed the transfer petition tag with this cause list 305
that is a transfer application
filed by the wife, your lordship.
Wife file.
Which petition? Transfer of which petition?
Section 9 petition, your lordship.
Section 9 from
Bhubaneswar to Bargad.
So you agree for that or you want to register?
ଆମେ appear କରିବା ସେଥିରେ just
TRPC number 305 of 2025. The matter is listed along with the connected TRPCRL 36 of 2025, which has been considered and disposed of today. So, the office note put up by the registry indicates that notices issued earlier has been returned answer with postal endorsement, no such person in this address. So, the learned counsel, Mr. Pasad, who is appearing on behalf of the opposite party in the connected petition. He being the petitioner submits that he has instructions to appear on behalf of the opposite party. Give it some time. He shall file Wakalatnama on behalf of the stop. Accordingly, how much time, sir?
1 week time.
Accordingly, the Wakalatnama, duly executed Wakalatnama shall be filed within 7 working days upon filing of the Wakalatnama. The same shall be taken on record. Name of the learned counsel appearing for the opposite party shall be reflected in the cause list as well as the case brief. The matter shall be listed in the week commencing. Notice is which?
Notice is
listed for admission in the week commencing. 11/5.
11/5. Sir, in this case, my learned was said that no stay of further proceeding also.
But the last interim order is there, your lordship. अब तो order फैला पर last
11/5.
अपन तो
Interim order passed. Interim order passed earlier. Interim order dictated 9/25 shall continue till the next date of hearing.
Item 38.
Under this, no.
Item 38, my lords. My lords may kindly peruse para number order dated 11/3/2026, para number 10.
Petitioner Mr. Dundavan Rao for OP number 1 and 2. Order dated, Mr.
2026.
11/3/26.
Para number 10.
Yes.
My lords.
Copy of this order shall be forwarded.
My lords.
Yes.
The copy of this order shall be forwarded to the learned Deputy Solicitor General of India to obtain instructions.
Copy has been forwarded. We sought for instruction also. Till yet instruction has not reached. Any other date you are also fixed. So we will further send you this.
Sir, Dundavan Rao click. Mr. Samantra, your full name is Samantra.
SK Samantra.
Mr. SK Samantra, Senior Panel Counsel.
No, CDC.
Central Government Council. On behalf of Mr. PK Party Senior Advocate, DSGI.
Yes.
The learned counsel for the petitioner refers to the order dated 11/3/2026, paragraph 10. So, in terms of the said order, the order has been forwarded to the learned Deputy Solicitor General, who has sought for instructions
On 23/2026.
23/2026, as submitted, as informed by the CGC. Stop. Awaiting the instructions of the CGC, the matters shall be listed in the week commencing 4/5/2026.
ସେଇ ଭାରତୀୟ ସୃଷ୍ଟି ଅଛି 40,000 ଟଙ୍କା ମେଣ୍ଟେନାନ୍ସ ଷ୍ଟେ ହେଇଛି 15,000 କଣ୍ଡିସନରେ ଦିଆହଉଛି।
ଦେଖିବା ବି ପେସେଣ୍ଟ ସାର୍, ଆପଣ କ୍ଲାଏଣ୍ଟଙ୍କ ଭଳିଆ ଇମ୍ପେସେଣ୍ଟ ହୁଅନ୍ତୁନି। ମ୍ୟାଟ୍ରିମୋନିଆଲ ମ୍ୟାଟର ତ ଇମୋସନାଲ ହେଲେ
ଫ୍ରେଶ ଆଡମିସନ ପାଇଁ ଯେତେବେଳେ ହେଇଥିଲା କିନ୍ତୁ ଆସିବନି ଆଡମିସନ ଆସୁଛି ସେଟା ଫ୍ରେଶ ଆଡମିସନ ଦେଇଥିଲା।
liberty to mention କରିବେ, what difficulty? I always grant liberty to mention. The matter shall be listed at the order se aschi na gone. The matter shall be listed for
admission.
Listed for orders in the week commencing 4/5/2026.
4/5.
Yes.
Interim orders to continue, my lords.
The order as passed earlier shall continue till the next date of hearing.
Obliged, my lords.
39. Ms. Mahanti. Very Mahanti for the petitioner. Yes.
Nobody has been appear on behalf of opposite party.
Trial court रे appear करना थी। So you have to, I mean, your learned counsel who is appearing and handed over the brief, seeking transfer, he or he has to cooperate with you. You ask the learned counsel to give you the next date, so that a direction can be issued that the notice will be issued through the court.
Final. Yeah, appear କରୁନାହାନ୍ତି ତିନିଟା date ହେଇଗଲା.
When in a pending proceedings, something becomes very easier, even if somebody is avoiding. Direction thila service through the court.
Final disposal पे 19/12/2025 रे भी order ହେଇଥିଲା. 19/12/2025 रे. Para 3.
The solve ହେଇଯାଇଛନ୍ତି sir. Safety status କଣ case sir?
No, I don't know.
ମାନେ ଆପଣଙ୍କ କ୍ଲାଏଣ୍ଟ ବି କିଛି ଇନଷ୍ଟ୍ରକ୍ସନ ଦଉନାହାନ୍ତି?
ଦେଇନାହାନ୍ତି.
ଆଚ୍ଛା,
ସେ ଖାଲି ବ୍ୟସ୍ତ ହଉଛନ୍ତି.
ସେଠି କଣ status କଣ ବୁଝନ୍ତି? I think the matter has proceeded there or not proceeded.
ଆଜ୍ଞା.
ଆପଣ police notice
ଆଜ୍ଞା.
pursuant to the directions issued by the 48th bench by order dated 15/9/2025. ଆପଣଙ୍କର stay ଅଛି ଆପଣଙ୍କ favor ରେ.
ଆଜ୍ଞା.
So would you want that stay should be vacated?
Yes.
I'm just asking you as a lawyer, not as a judge. You have obtained stay.
Yes.
Other side appear କରୁନାହାନ୍ତି.
ଆଜ୍ଞା.
So if you want proceeding there to proceed there, then you can simply withdraw the application. Petition was filed by whom? I think by the opposite party. Yes. In the trial before the learned judge family court, you are the opposite party.
Yes.
Now you have obtained a stay.
Yes.
So that is in your favor. About instruction नियंतु.
ଆଜ୍ଞା.
Mahanti, sorry, for the petitioner, opposite party none. The learned counsel for the petitioner seeks adjournment to obtain up-to-date instruction regarding the up-to-date instructions from the opposite party. The matter shall be listed in the week commencing. 11/5/2024. You talk to the lawyer.
Yes. IN number, my lord, IN number 299.
Interim order passed earlier shall continue till the next date of hearing.
Obliged.
Madam, 40.
I was looking.
No, in fact, I was thinking to not to open any further brief, but I thought that I'll just run through the list. তিনটা 45 ভাবুଥିଲି. Mr. Mohanty, can mediation work here? Because if it is apportionment.
I only dispute. We are disputing the status, their status as sister. Actually, we have succeeded 50% because the out of the awarded amount, whether they succeed or whether I succeed, I get half. So half is assured by your lordship's and only necessary.
That matter. I have passed an order that.
So, and the only rest person, your lordship can. I don't have any objection for mediation.
So, can be disposed of, my lordship, sir. Because they have admitted, my lord. My senior also know it with very. The appellants here, my lord, they have admitted that we are the sister of my lord.
No, appellant admit this. There is a technical review. One of the co-respondents has admitted.
Yeah. appellant had
evidence देनी
evidence अच्छी ना that
Daily
is
पर
the
सर कुछ नहीं
deflect-
daily में.
yes
Prasanna is not the appellant here.
The Usavati is the appellant.
Usavati Prasanna रहेगी
Mr. Ramakanta Mahanti, Senior Counsel, along with Mr. Animesh Mahanti for the appellate. Mr. Anshuman Sethi, Additional Standing Counsel for the plural, appellants, plural. No, it's singular, appellate, keep it. Appellate. The Anshuman Sethi for the Proforma respondent number 3, AC. Upon Mr. Sahoo?
No. 1 and 2.
1 and 2.
My
Mr. G.N. Sahoo.
My seniors.
Mr. Ekenanda along with Mr. G.N. Sahoo for R1 and 2.
My
opposite party actually. So appellant respondent. Appellant. Yes, Mr. Sahoo. Mediation.
I have no objection. I'm a party to it.
I mean, actually, the mediator should be equipped with that what is the possibility. So that way I was thinking.
Mediation, your lordship is correct.
The matter is pending since 2016. Or you want to obtain instruction?
I'm making a submission that I have no objection for mediation.
Mr. Sahoo?
I'm already written not also submit for the
and suppose the mediation pay objection.
Well, this is a fit case. Mediation
I should take
mediation for nation 2.0.
My lord.
Basically, these are the cases which have been identified. It can be settled by mediation instead of fighting up to Supreme Court.
My yes. Mediation.
order कर दो ले
High Court, local.
High Court.
Because in Rayagada, somebody said that they can't travel from interior.
ଆସିବାର କିଛି ଅସୁବିଧା ନାହିଁ ବୋଧେ
ବହୁତ ଲୋକ ହେଇଯାଇଛନ୍ତି ବର୍ତ୍ତମାନ ତାଙ୍କର ଲିଗାଲ ସମସ୍ତେ କେମିତି
ସମସ୍ତେ ଘରେ ଆସିବେ
ଯଦି ସେଠି ଚାହିଁବେ ତାହେଲେ DLSA ଯୋଉ ଡିଷ୍ଟ୍ରିକ୍ଟ ରେ ଯୋଉ ରହୁଛନ୍ତି
କିଛି ଆମର I have no objection. ଯୋଉଠି ସୁବିଧା
ଆପଣ କଣ କହୁଛନ୍ତି ହାଇକୋର୍ଟ ନା DLSA ସେଠି କରିବା ଏଟା କୋଉ ଏରିଆର କେସ୍ ସୁନ୍ଦରଗଡ଼
ସୁନ୍ଦରଗଡ଼
The land acquisition appeal is pending since 2016. The appellant is now aged about 75 years. The opposite parties respond. Sorry, R1 is now aged about 80 years. R2 is now aged about
R2 has expanded.
70.
R2 expanded.
R2 has in the meanwhile has passed away. In considered view of this court, this is a matter fit which should be referred to the mediation for nation 2.0. Considering the fact that the matter is from the district of Sundargarh, about how many kilometers?
300 some odd.
Which is more than 300 kilometers distance from the High Court. It is directed that the matter shall be referred, the matter shall be included in the mediation for nation 2.0. The parties the parties shall appear before the parties through their counsel shall appear before the Secretary DLSA Sundargarh for appointment of a trained mediator and further proceeding stop. Soft copy of the entire records shall be forwarded to the Lorded Secretary DLSA Sundargarh, the Lorded Counsel, Lorded Instructing Counsel for the appellant, as well as the Lorded Counsel appearing for the respondent. The parties
fix karibe jodi karbe.
parties. The DLSA, the secretary DLSA shall fix a date and intimate the parties in their respective addresses. The matter shall be placed. The matter shall be listed for orders in the commencing 11/5/2026. On the said date, instructions from the Honorable Secretary DLSA regarding the progress in the mediation, such as notice to the parties, appearance, etc., shall be placed on record. The Honorable Secretary DLSA is requested to furnish a report to the registry of this court. Yes, Mr. Mahanti, anything?
ସେ କହୁଛନ୍ତି ଛୋଟ ଅଳ୍ପ ଟାଇମ ହେଇଗଲା ମାନେ ହେଇପାରିବ କି ନାହିଁ
Mediation time to ରଖିଲି what you are saying exactly, I am conscious of that.
ନାଇଁ ତାଙ୍କର ଯଦି ଡିଫିକଲ୍ଟି ହବ ସେ କହିବେନି ତାଙ୍କର ଡିଫିକଲ୍ଟି ସେ କହିବେ
Say sufficiency of notice and appearance of the parties. That much I have specified. Otherwise, usually I say that
ଆଉ ଗୋଟେ ଅଛି subject to your lordship's consideration. Both parties are here. If you can fix a date, we both will appear before the DLSA on that.
ठीक ଅଛି date you can suggest.
ଏଇ ଗୋଟେ 15 ଦିନ ଖଣ୍ଡେ mediation 15 ଦିନ
instruction then is a location contact nahi
15 ଦିନ ଖଣ୍ଡେ time ନାଇଁ ଖାଲି
The parties need to advise the parties are also requested to appear before the Honorable Secretary DLSA on Ajioji.
My lord, one thing. My lord, one thing.
Just one second. Aji 9 तारीख. 10 तारीख. आज 9 तारीख ना 27 तारीख को रखले हो on 27/4/2026. Yes, Mr. Bose.
My lord, I don't have any objection to what my land senior move. Your lordship,
no, it is not Mr. Senior Mr. Mahanti's submission is not that. I mean, the matter was to be argued on merits. But looking at the case and the age of the parties, this is a fit case which should be included in the mediation formation.
My lord, may I say one thing? My lord, if there are all your lordships have made provision of mediation all over the state.
City କରୁଛନ୍ତି ପରା
ଏଟା ସେଠି ପଳେଇଲାଣି
ସିଟି କଲ
ଆପଣ ଆସିଲା ପୂର୍ବରୁ ଯାଇଛି ଭାଇ
ସେଇଟା ସିଟି କଲ 27 ତାରିଖ ଦିନ appeal କରିବେ ସେ ତାଙ୍କ ଡାଇରେକ୍ସନ ଦେବେ
They will issue notice because generally the problem is once
what Mr. Mahanti was saying that today, in fact, I have observed in that Raigada matter, they came from interior Koraput, Jaipur. So only two of one representing each parties they appeared. What Mr. Mahanti was saying, Senior Mr. Mahanti was saying. Thereafter, they have sought for time. They were explained. The cost of litigation, consequences of a prolonged litigation, and unfortunately, the younger one has passed away. Amongst the litigants, the younger one has passed away.
Hey, what my learned friend is saying, I think your lordship has taken care in the
there is some difficulty for them to come to Cuttack and appear. And in fact, in one case, you suggested that cost should be paid in Cuttack. It was his submission actually.
Malad, that is in case of
matrimonial. Yes.
Matrimonial.
Yes.
Malad, one thing, if your lordship is kind enough to add one minute, that the DLSA will issue notice to the party.
Take instruction.
But from issuance of notice, they have the choice to appear, so that DLSA will not search for them. Because it has a distinct advantage.
Because we are appearing here.
Because I am not saying
my problem is
citizen notice
my problem is I have no contact, direct contact with the
that is the issue. Because
and the lawyer that is no more.
Because Mr. Sahoo, Mr. Hon'Ble Mahanti, they are not taking the responsibility there to appear there.
Yes.
We usually doing. Mr. Mahanti and Mr. Sahoo will appear before the coordinator and take a take. That cannot be done here.
Say notice karibe.
And the parties can also be intimated.
Yes. My appearance may be not.
Mr. AP Bose for R5.
8A to F.
8A to F. Right. Thank you.
Oblige.
Okay.
My